All right, good morning, Morena, everyone. Welcome to this hearing. We'll just start now. My name is Dr. Lee Beattie. I'm the chair, and I'm ably assisted with Miss Wendy Baker here, sitting next to us. Thank you for joining us on live. We're on streaming live, and we're also on Zoom. Unfortunately, given the short time frames between the government's decision to change settings and such like, we couldn't get a hearing date and such like to do this in person. So please bear with us while we're over Zoom. I'd just like to say before we go any further on that, if your cat, dog or young kid comes into the background, that's perfectly acceptable, and we've all got quite used to that space. So welcome to the hearing. We'll obviously ably assist with the lovely Ms. Trish Anderson. All things go through her as usual. We're here to consider the application by Victoria Buckham, RM201050, to undertake activities, and that's part of the discussion, at the property at 31 Speargrass Flats Road, as set out in the agenda. Before I go any further, I'd just like to get everyone to introduce themselves, and then I'll set out the process for the hearing today, and we'll go from there. But just before I do that, I'd just like to confirm that we visited the site yesterday. Thank you very much to the applicant for allowing us to come onto your property. We also looked at from the neighbouring property. Thank you very much for allowing us to come onto the neighbour's property. We can confirm that no conversations took place as part of that visit. And we'd like to also thank you for opening up all the buildings for us to have a look at. So on that note, I'd just like to pass around and everyone can introduce themselves. So do we mind if we start with you, Ms. Volt, with you and your team? Are you there?
Yes, yes. So I'm here on behalf of Mrs. Buckham, and I'm here. In the room with me is Brett Giddens, Mrs. Buckham's planner, Rob Hay, the acoustic consultant, Robin Miller, heritage advisor, and also Mr. and Mrs. Buckham, and Jason Bartlett is in the UK, and there he is there. So he will just housekeeping. I'll try and get him. I'll get him to present his evidence relatively early in the process, because he's about 12 hours difference in time. So
thank you very much, Ms. O'Connell for the council. Are you there with your team?
Good morning. I'm so sorry, and my apologies is that my camera is not working, but I will turn it on as soon as it is. Good morning, everybody.
And you have with you?
I have with me right now Steve Hewland, Richard Knott, and John Stiles has sent his apologies, and he will be joining at about 11 a.m.
Thank you very much, Ms. O'Connell. Do we have any submitters? I've noticed that Ms. Anderson just gave us an updated list, and I'll just go through that in a moment with also the other documentation we've just received. But I've just got an updated list from her saying that a number of submitters no longer wish to speak. But we do have some time set aside for tomorrow, and we'll talk about that also in a moment, with Jane McDonald, I think, is representing quite a few submitters. But is there any, are you there, Ms. McDonald, and is there any of your submitters with you?
No, it's just me at the moment, thank you.
Okay. Is there any other submitters that are not represented by Ms. McDonald there, online? Okay, all good. So we've got you down tomorrow, Ms. McDonald, at 9 o'clock. And you're representing quite a few parties, is that correct?
That's correct. And I'll have Ms. Tate and Mr. Trevathan to speak to their evidence as well.
Okay, thank you very much, Ms. McDonald. All right, so just before I go any further, just to confirm the information that we've been given to us, as Ms. Anderson's given us the updated list of who Ms. McDonald's representing and who's speaking. We also have Ms. Volt's opening summary of her legal submissions for us, or a summary of her legal submissions and her legal submissions. We also have summaries of evidence from her witnesses as well. Can I confirm, Ms McDonald, you and Ms McConnell have all that?
Yes, received that this morning. Thank you.
Thank you. Ms McConnell, for the council, you've got all that?
Yes, we do have all that. Thank you.
Okay. Given I was going to go through a spiel about how the process works, given I think that everyone in the room is quite cognizant of how the process works, I don't see any value in that type of process at this point. But before I pass over to you, Ms Voll, is there any procedural matters anyone would like to bring to our attention before we start? Okay, thank you. It's always a bit difficult on Zoom, and as I say, don't be afraid if the cat, or if I was at home, the cat would probably be across the screen already, so don't be afraid if that happens. Ms Voll, I'll pass it over to you.
Thank you. So I will read my summary of legal submissions, given I assume you won't have an opportunity to look over those yet, and also because the legal submissions I filed last week were very comprehensive and quite lengthy as well. So if I just start at paragraph 1, I don't know if you have copies of those in front of you.
So that's the document that's 17 pages long?
Correct, yes. That was provided this morning.
No, so, just Ms Voll, we haven't actually received, and our apologies, we haven't received the lengthy, in your words, and I don't mean that inappropriately in any shape or form, the 45-page document. We haven't seen this until today. Do you think there's benefit in you going through that, or do you think the 17, your summary is good enough? I'm really in your hands, or we're both in your hands about what you'd like us to do, because unfortunately we haven't seen this until today.
Right. Look, I'm happy to go through the summary on the assumption that you will read the more lengthy document in your own time. That really goes into a lot of detail about the evidence and analyses the evidence and the views reached by the various witnesses and the robustness of those views. So I do think it's important you read those. There's also that the law is also set out in quite some detail there, but I think for the purpose of opening this case, that the summary I have filed this morning is sufficient. And no doubt if you have questions, I can perhaps take you to the more lengthy document.
Sure. I mean, time's not an issue for us. If you, I'm totally in your hands. We're happy, obviously, to go for the shorter one, but of course we will be reading the longer one. Probably reading it tonight, to be honest.
I'll just be.
Can we have a Actually, we thought about this. It probably would be better if you went through the. I'm sorry to put you on the spot here and go for the longer document. We do have the time. It's just that way, if we do have any questions, we can just deal with them. Sorry to put you on the spot like this. I know it's a bit more reading for you.
Oh, more listening for you as well.
No, it's all good. I mean, my colleague's correct. If we do have, it's better that we go over this now with you, so that if we do have any questions, we don't have to come back to you. We can just get it all. It's all clean. We've done it now.
Okay, well, I'll start with the submissions then, and I just say, as I've indicated, I've in these submissions I've comprehensively addressed the evidence and in some respects touched on matters that might ordinarily be touched on in closing, but I think the evidence is obviously it's critical in this case, and the interpretations of some of it have impacted the assessment of the proposal overall. So I think it's necessary to carefully consider the evidence and where there are problems with it. So I apologise in advance for the length, but I'll take you through as quickly as I can. So if I just start at paragraph 3.
That would be lovely. Thank you.
In broad terms, the proposal is to undertake, sorry about the typo there, up to 100 temporary events per annum at Thurlby Domain. The proposal has been substantially refined since notification and now includes provision for up to 100 events per annum, inclusive of events at the ruins, for up to 150 guests across 2 indoor areas, that's the farm building and the stables, and 3 outdoor areas, being the ruins and outdoor areas 1 and 2, between the hours of 10 a.m. and 11 p.m. Now they're the maximum hours, but of these temporary events, only 12 may occur between these hours, and that's in either the farm building or the stables. And all guests must be off site by 11:30, while all other events must cease by 8 p.m. with guests off site by 8:30. So despite what I've said in 4A, the hours are really 10 a.m. Until 8 p.m, but for 12 evening events, which may run through until 11 p.m. So in addition, there are...
So just to clarify for our own mind, just if you don't mind if we go along. So those 12 events don't apply, just so I'm clear, don't apply to the outdoor areas, they only apply to the farm building and the stables. So that's the events that we'll have potentially after the 10 p.m. period. Is that correct?
Yes, that's correct.
Thank you. So I interrupt you.
4B, the proposal also includes controls on music as part of temporary events, including with regards to the hours and areas where music can be played, decibel levels, and the nature of the music, with a very limited provision being made for music outdoors and in the evening hours. And just to pick up on your previous question, the provision for music in the evening hours is only inside those two buildings, the stables and farm building. There is no provision for outdoor temporary events in the evening hours, other than for the limited use of the large area between the stables and the farm building. We've called that outdoor area 2, and that can be used as a breakout area for guests participating in evening events in these buildings. For the avoidance of doubt, evening events at the ruins are no longer proposed.
Ms. Wald, I just want to check here, because one of our unclarities in reading this evidence was what has actually been changed, because all the evidence is a little muddled in that respect. I understand there's also a 6-hour limit on any event.
Correct. Yes, there is. And yes, this has been quite an iterative process in formulating the proposal, and that is due to the complexity of the site, and also how it needs to be assessed under the district plan. So the proposal has changed, and that's touched on in the evidence that's been filed, but also the way we'll present this case to you is after I present my legal submissions, Mr. Giddens will run through the consent conditions now proposed, now provided by Ms. Anderson this morning, and that will hopefully provide you with a clear picture of the proposal as it now stands. And so what I've set out here includes amendments that have been made through the course of the applicant's evidence, and then in some instances also subsequently, to really refine the proposal and nail down exactly what can occur and where. So if I just take you back through to 4D, so we're also proposing...
Sorry, Ms. Wald, it is very important for us to understand what we're actually assessing.
Yes.
To be a little bit, it's obviously changed a lot, we understand that, but we had expected there to be a document setting out what was now actually proposed, and that seems to be this section of your submission. So can I add C, a 6-hour limit on any event? Is that correct?
Yes, that is correct.
Okay. And if there is anything else, it would be helpful to add it to this list, because this seems to me, having read all the evidence, to be the most comprehensive list we have of what has changed.
Yes, look, I do touch on all those matters, perhaps not as specific maybe as you would like, and that I've alluded to the fact there is a limit on the duration of events and so forth. I wonder if it might assist if, before I get into my submissions, if Mr. Giddens presents the overview of the proposal and takes you through the consent conditions now proposed.
Well, no, I think we, sorry, I'll just sidebar for a moment here.
No,
hang on, I've just, yeah.
So no, just box on. Thank you very much. We'll just see where we go. I mean, at the end, maybe it's part where if we need to, we can get some sort of thing, because I do have some other questions about the actual activities that are taking place, but maybe that's played out in your submission because we haven't read all this. So let's just see how we go.
Yes, okay. So 4D also proposed the limits on the regularity of evening events and provision for a period of respite. And just to elaborate there, Mr. Giddens will present conditions which limit how many evening events can occur per week and on consecutive days. And related to that, a period where they can't occur, which is the respite period. So there's also a requirement for the construction of a replacement fence of appropriate design on the boundary with 67 Speargrass Road, and that must be constructed before any temporary events can occur in the courtyard area adjacent to this boundary, and that's outdoor area 1. And the fence will serve both acoustic and privacy purposes. There is also now proposed a limit on the number of temporary events that can occur in outdoor area 1 and on guest numbers. So that is new. Mr. Giddens will explain that is a limit of 24 events per annum, and with each event having no more than 75 guests. There's also a limit on guest numbers for temporary events in the stables. Again, that's 75. And on the hours that music can be played and the nature of that music. So to elaborate there, that is only background music and only up until 10 p.m. There is a requirement for the consent holder to acquire and install a calibrated sound limiting device for temporary events in the farm buildings. And that's, I think, been made clear in the evidence and proposal details of the proposal given previously. Restrictions on the location of marquees, portaloos, catering facilities and related activities, and that is in Mr. Giddens' evidence, where he has included an amended site plan where he has identified the 2 particular areas where these facilities can be located. There are controls on access and parking for temporary events, including signage and lighting requirements for parking areas and the adoption of management measures for larger vehicles and parking during inclement weather. There is a prohibit on parking on Speargrass Flat Road. There are detailed requirements as regards to the preparation of a noise management plan and the implementation of the plan. A requirement to install interpretation panels detailing the interesting history of the property, and also a review condition. And as I've said, Mr. Giddens will take you through those in some detail. Paragraph 6, many of the refinements were foreshadowed in the response filed on behalf of Mrs. Buckham to the Council's Section 92 request in response to questions posed in that request, and also matters raised in submissions. Other refinements have been made in response to issues raised in the Section 42A report and in the submitted evidence recently filed, and they are therefore not accounted for or assessed in that report or evidence. The refinements demonstrate Mrs. Buckham's commitment to being a responsible and good neighbour and a committed custodian of her heritage property. She is very cognizant of the issues raised by the Council and by opposing submitters in their submissions and evidence, and while not accepting many of the allegations or criticisms made in the submissions about previous events and other irrelevant matters, she has substantially refined the proposal to address submitters' stated concerns and to ensure that the intended use of her property for temporary events is clear, the character and the character and amenity of the environment in which she and her neighbours reside is maintained. And to this end, this might explain, I guess, some of the changes that have been made to the proposal. To this end, when submissions were received on the notified proposal, Ms. Buckham saw fit, in light of matters raised therein, to seek a review of the noise assessment that informed the application for the proposal as lodged and notified. This review was undertaken by Mr. Hay of Marshall Day Acoustics. Through the review, Mr. Hay identified some deficiencies in the original noise assessment, and Mrs. Buckham sought Mr. Hay's advice as to how these could be addressed, including any changes required to the proposal to ensure that the conclusions on effect remain sound and the proposal appropriate for its location. Mr. Hay's recommendations are encapsulated in the revised proposal. The property and its use, well, you visited the property yesterday and you will have seen that it's a large, vegetated and very picturesque property. It includes an enclave of listed heritage buildings and numerous protected trees. The heritage buildings and the related plantings are described in the evidence of Mrs. Buckham and Mr. Miller. And rather than read through these next paragraphs, I might just summarize this page, which is that the buildings were constructed in the 1880s, and at the time they were the grandest buildings in the district, constructed for Hallenstein, Bendix Hallenstein, who's the founder of the Hallenstein Brothers stores and DIC, and was also a mayor. But he left the district not soon after they were constructed, and over the course of the following years, the building sadly fell into quite a state of disrepair and decay. And they were left that way until the Buckhams acquired the property in 1991 and invested considerable resource into restoring the buildings, resulting in the listing, a heritage category 1 Heritage New Zealand listing in 2014. And that was as a direct result of the works they undertook. Paragraph 16, again, I'll just summarize these paragraphs. Temporary events, or the property lends itself to temporary events, and you might have seen that when you visited it yesterday, and they have in fact been undertaken on the property since the Buckhams acquired it in the early 1990s. And that is not due to the Buckhams actively seeking out this use, but to people approaching them to use the property for the special occasions. The Buckhams remain happy to share the property with people who wish to use it, including people who just frequently wander on to it, believing it is a public reserve, perhaps due to the name. And the Buckhams take no issue with that, provided the property is respected. They see themselves as custodians of the property and are committed to ensuring that it endures for future generations. Paragraph 22. Over the course of the Buckhams' ownership, the demand to use the property for temporary events has grown, and that's from community, school, church and recreational groups, and also from private individuals for special events such as weddings and other celebrations. The 14 temporary event permissions under the district plan across the property's 2 sites are insufficient to cater for this demand. And I'll touch on well, actually, if I just touch on it here. So the property is, in terms of the district plan definition of site, the property contains two sites. One site contains the ruins, and the other site contains all the other heritage buildings. So in terms of what the district plan permits under Chapter 35, it is 7 temporary events per site. So across these 2 sites, there's a permission for 14 temporary events. Paragraph 25, the ongoing maintenance requirements and associated costs are significant, and you will have seen the evidence or the figures provided by the Buckhams, which Mrs. or Mr. Buckham will discuss in their evidence today, and that those costs are around $40,000 to $50,000 per annum on average, and the Buckhams fund these works themselves. As well as facilitating the greater use and appreciation of the property by the public, the proposal to increase its use for temporary events provides an opportunity to realise an economic use for the buildings and grounds, which will surely aid the ongoing maintenance and upkeep. So at paragraph 27, I've set out the evidence that has been filed as per the introductions. That's acoustic evidence of Mr. Hay, traffic and transportation evidence of Mr. Bartlett, heritage evidence of Mr. Miller, and planning evidence of Mr. Giddens, as well as evidence from Ms. Buckham herself. And summaries of this evidence will be presented at the hearing, and these summaries will also respond to matters raised in submitted evidence. For the council, the Section 42A report prepared by Ms Connell includes her plan and assessment, and reports by Mr Exeter on noise and Mr Wardle on, Mr Hewland on traffic, and also heritage by Mr Knott. And you will also have read the opposing submitted evidence on noise planning and also a heritage letter. And I'll address this evidence throughout these submissions. So the issues as raised in evidence are the nature of the proposed activities and whether they are in fact temporary events, the application of the permitted baseline, noise effects, heritage effects, cumulative amenity effects, the relevant objectives and policies, precedent risk and conditions. So to summarise the Section 42A report, Ms McConnell does not agree that the proposal is for temporary events due to the scale and nature of the proposed events, which she says could reoccur regularly in perpetuity. She considers the proposal as for commercial activities, and when assessed as such, it is contrary to a number of relevant objectives and policies. And so in that regard, she's assessed the proposal under the applicable zone rules contained in Chapter 24. Her assessment of the objectives and policies is informed by her assessment of the effects, and in that regard, her assessment is that the proposal will result in minor effects on the character and amenity values of the environment, more than minor effects on historic heritage, although the proposed fence will have less than minor effects, minor to more than minor effects during the 12 possible evening events, that's noise effects, less than minor traffic and transportation effects, less than minor surveyed scene effects, but more than minor cumulative effects, and she also identifies some positive effects. Unfortunately, for some matters, Ms McConnell's effects assessment proceeds on the basis of a misunderstanding of technical expert evidence, and that's noise, or relies on evidence that is flawed, and that's heritage. And this impacts the reliance that can be placed on her effects assessment. Further, when assessing the effects of the proposal, she has not taken account of the permitted baseline on the basis of an erroneous understanding of when that should and should not be applied. This has also likely affected her assessment of effects and in turn the objectives and policies. Ms McConnell's report was, as I've already noted, prepared prior to filing the evidence for the applicant, and she did therefore not have the benefit of that evidence or of the further revisions to the proposal when preparing her Section 42A report. And in light of the errors outlined, and after taking account of the further refinements, she may wish to reconsider her position. Submitters in opposition, in short, the evidence for those submitters is that while the effects of the proposal, when considered individually, may be capable of being remedied or mitigated to an acceptable degree by the imposition of conditions, when considered cumulatively, these individual effects result in the sum being greater than its parts. And the effects on amenity values, in particular, of 67 Speargrass Flat Road are more than minor. On this basis, the proposal is found to be contrary to the relevant objectives and policies of the PDP. Precedent and plan integrity issues are also raised. And the submitter group also takes the position that the proposal is not for temporary events. Numerous submissions have been filed in support of the proposal, and it is understood that while there was originally an intention to do so, a few submitters now wish to speak at the hearing due to the perceived difficulties of doing so remotely. We do nonetheless need to take these submissions into account. The position on behalf of Mrs. Buckham is that when the wording and structure of Chapter 35 and the relevant definitions are properly assessed, interpreted and applied, the proposal is plainly one for temporary events. The proposal will have no more than minor adverse effects, including cumulative effects, particularly if regard is had to the further refinements proposed. The proposal is not only consistent with the relevant objectives and policies, but finds support from a number of the most important and relevant provisions. No issues of plan integrity or precedent arise. The proposal will give rise to significant positive effects in terms of historic heritage in particular. These conclusions withstand whether the proposal is assessed as a temporary event or under the provisions of Chapter 24, and the proposal should be granted. Now, in this next section, I have gone through in some detail the approach to interpreting the temporary events definition and applying that in the context of Chapter 35 and this proposal. And I also picked that up in my summary as well. And Mr. Giddens has covered that off in his evidence too. And I could take you through that, but I guess the case for Mrs. Buckham is that, as I've just said, no matter how the proposal is assessed, it meets both gateways. And the significance of the temporary events definition and whether this proposal is for temporary events is the objectives and policies that you need to look at when applying Section 104D, and whether you can draw on the support that of the objectives and policies that are contained in Chapter 35. And my submission is that this clearly is a proposal for temporary events, and that much is clear from the plain wording of the temporary events definition, which lists expressly the activities to which this proposal relates. But if you don't take the same view, then nonetheless the proposal flies through both gateway tests. So I would be happy to take those submissions as read, because I think the better focus here is on, well, what are the effects of the proposal and how does it stack up against the objectives and policy.
So at this point, can I ask you, because it raises an interest, so if I understand what you're saying correctly, you're saying it doesn't matter if we come to the view it's a commercial or a permitted, a temporary activity, it would still fall through the requirements of the relevant policy frameworks on the 104D.
Yes.
In doing that, can I ask you, because your submission, if I understand correctly, and reading Mr. Gibbons' evidence as well, is that it is a temporary activity, and that Part 24 or the underlying zoning doesn't really apply. What really applies is Section 35 of the plan. I'm interested with that viewpoint. Is that so? What you're saying is that even though we have a temporary activity that's covered by Section 35, doesn't the underlying zoning provisions still apply regardless of whether it's a temporary activity or not? Don't we still have to go back to the underlying zoning provisions in any event?
No, you don't. No, you don't, because Chapter 35 takes precedent over those provisions, and there's a note to that effect at the outset of the chapter. Right. So it overrides those provisions. So if this is a temporary event, Chapter 35 is the one stop, with the exception of heritage and signs. However, this is a proposal for a non-compliant activity because the noise permitted, the nighttime noise is breached, and so therefore you probably need to go and look at the Chapter 24 objectives and policies to some extent in any case, whether or not this is a proposal for a temporary event or a commercial activity. And so I guess I don't want to focus, whilst this is a clear position, I don't want to focus on it because I think it risks becoming a bit of a sideshow when
that's our feeling as well, potentially, that it is, or potentially, and I don't want to take away from what you, I'm glad you said that, because we were thinking the same thing. The only thing we totally take your position on what you're saying, so I totally take the position that maybe we should just leave this for our reading and move on, as you say, onto the effects and go from there. But just one thing, we're not going to run into that scenario, and sorry to use an Auckland Council example, and my apologies for that. I don't know if you're aware of the scenario where they had a few years back, where they had the overlay of the character provisions. The Auckland Council was not applying the underlying zoning provisions, and the Environment Court took a very dim view of that, and that you had to apply both the overlay and the underlying existing plan provisions of the zone. That wouldn't apply here because of the actual bit that's put into Section 35, into
Yeah,
Do you know
yeah.
the case we're talking about?
I don't know the case you're talking about, but I understand the point you're making. I don't believe that that situation would arise here. I think the intent is quite expressed in the plan that the temporary events under Chapter 35 are given a much easier consenting pathway because of the significant benefits that they bring to the district.
Okay, thank you. So
just one final point.
I'm comfortable with us skipping that, and I just want to clarify. You said originally, and I made a note that it's only of significance in that you'd only have to consider the objectives and policies of Chapter 35, and then later you said no, actually you'd have to consider 24 as well. I just want to confirm what you're telling us.
Well, what I'm telling you is a non-compliant activity. You need to look at whether it's a Chapter 35 applies or not. You need to look at all relevant objectives and policies in the district plan. Right. And so it would be appropriate for you to have some regard to the objectives and policies in Chapter 24. However, I would say you'd need to the weight you might give to those, or where the focus of your assessment might lie, would be influenced as to how the activity was framed. And if it's a temporary event, you also need to look at the very supportive objectives and policies in the temporary events chapter. But I guess the way we've approached it is to assess those objectives and policies in Chapter 24 in any case, and we are, based on the noise evidence in particular, very comfortable that it stacks up against those provisions and meets the second gateway test.
Okay, thank you. So, well, I've just got a few questions before we get into the effects at the beginning. Shall we go over that since we've had a break? Because it is really good for you going right through the thing, because it does give us the thing.
Sorry, if I could just make one further point about this temporary events issue. Unfortunately, whilst I've just said let's not get distracted by it, it has impacted very much so how Ms McConnell has assessed the proposal, and she's taken the view that because she's assumed this is a proposal for a commercial activity, therefore cannot find favour under the Chapter 24 objectives and policies, and that is in my view incorrect, and Mr Giddens details why that is so, with consideration to actually what Chapter 24 provides for and anticipates in terms of commercial activities. So I do think you need to, as I've said, approach Ms McConnell's assessment with some caution because of the manner in which she has assessed it, and what her conclusions on whether or not this is a temporary activity have meant for her overall assessment.
No, totally cognizant of what you're saying, totally cognizant of that. Just going through, can I ask, going right back to the when we talk, and this is something that's come up for both of us, is the issue about the fence. I've not seen any plans or any, apart from a sort of a description, but I haven't seen any plans or any of the fence. So that's the first bit. The second bit, would the fence require a historically placed structure, or whatever the appropriate term is, consent, because it's potentially in the curtilage of those Grade 1 listed buildings?
Yes, we've applied for consent on that basis. So there are no plans as such of the fence, because we are proposing a condition which requires those to be, or the design of the fence to take account of the recommendations contained in Mr Miller's report that was appended to the applicants, or to the RFI response, and there's some detailed assessment in that about the various methods of construction and which might be appropriate and which might not. So the intention is to, or the proposal is to include a condition which requires reference to be had back to that assessment, and then for the council to certify that it's happy with the construction of the fence. And in terms of the consenting requirements, it's a bit of a case of how thick is the line on a plan, because the scale of the heritage listing in Chapter 26 is, it's a little wee picture with a big thick line, and the fence is proposed to be located probably on the line, maybe outside it. We couldn't be sure, but we've assumed that it is within the extent of place as listed in the plan, and have sought the heritage advice of Mr Miller on that basis as to whether it's appropriate, and if it is, how it ought to be constructed.
Thank you. We'll pick that a bit further. Yeah, go on.
Well, so sorry, Ms. Vold, the extended place, does that extend all the way to the boundary if you take the thick line at its largest extent?
Well, I couldn't be sure because of the scale of the plan, but that is the assumption. That's the conservative assumption we have made, but your guess is as good as ours, I guess, when you're looking at that image.
Okay. Just coming back to Kate, I assume that obviously that's a provision of car parking. That's something that the council would have to control, wouldn't it? With the yellow.
Sorry, Commissioner, where are you?
I'm going right through the issues of right back to, so my M4, just going through the details of the application. 4.K, you talk about the provision of car parking on Speargrass Road. Is that where, are you seeking from the councils or road controlling authorities on the yellow lines putting along the road there? I'm just thinking, how could your client control that?
By communicating that requirement to all persons wishing to use the site for temporary event, and then policing it.
But they can't, I don't think they have the ability to stop people parking on the road, do they?
Well, I think if guests are using their site, they must use their site on the basis of the terms of hire, and I think that practically there would be no problem with the.
Sure. Okay. Cool. Just going back to section 8 and something else we can pick up with Mr. Hay. Did Mr. Hay visit the site when he did his assessment?
Yes, he's visited the site multiple times, and he's also undertaken testing.
Cool, thank you. No, the other thing that I think I'll probably pick up with Ms. Buckham about that what's actually happening in the past. No, it's all good. Any other questions before we move on to? Thank you. Shall we? Where we at? Shall we take section paragraph 66? Should we start at 69? So
yes. Look, so what I've set out the law here, and actually what I might do is just, I've got in my, and I'll just read this to you. In my summary, I've got a more succinct summary of the law, which I think is really what you need to, which might help you a bit more. And I'm sure you're well aware of it in terms of what you need to consider for non-compliant activities. So I just step away from my lengthy legal submissions and to my summary, which I can just read out. You don't necessarily need to have it in front of you. So paragraph 28, as a non-compliant activity, the proposal must be assessed under sections 104 and 104D and must pass at least one of the gateway tests. And these concern whether environmental effects will be more than minor and whether the proposed activities will be contrary to the relevant objectives and policies. What does minor mean? Well, it's not defined in the Act. The courts have said that it does not mean no adverse effects or only minimal adverse effects. Rather, it suggests adverse effects that are less than minor and can include those effects that are more than simply minute or slight. Whether effects are minor is to be determined after having regard to any mitigation of effects that might be achieved by imposing conditions. Counterbalancing effects may also be taken into account, as may the permitted baseline. The permitted baseline applies if the plan provides for a permitted activity for activities from which a reasonable comparison of adverse effects can conceivably be drawn. Then it is only the adverse effects over and above those forming a part of the baseline that are relevant for the purposes of assessing the environmental effects of a proposal. And in this case, as I've touched on, the permitted baseline provides for an extensive level of activity on the property, which is 2 sites under the PDP definition of that term. Most relevantly, it includes 14 temporary events per site per calendar year between the hours of 8 a.m. and 10 p.m. Sorry, that's the temporary events, in fact, are permitted between the hours of 8 a.m. and 8 p.m. But the noise controls don't apply between the hours of 8 a.m. and 10 p.m. And I think that is due to the fact that setup and pack down is permitted outside of the operating hours, and thus exempted from the noise limits up until 10 p.m. Temporary events can run for up to 3 days each, and that excludes set up and pack down, although all structures must be removed within 3 days of completion of the event. And each temporary event may host up to 500 people per event, but this includes staff, which can be additional. And as I've said, no applicable noise limits during the daytime hours, and in fact up until 10 p.m. So I say that this permitted baseline is not fanciful and ought to be considered, as there is an established history of the property's use for temporary events, and there's no debate about that. And the full baseline is relevant and should be applied. And Mr. Giddens addresses this further in his evidence. In terms of the not contrary to objectives and policies consideration, when you are...
Your summary completely now.
Pardon, was that sorry? I'm just on the law. So just up until, I'm just going through for the next 4 paragraphs, and then I'll jump back to my more lengthy submissions. So just because I'm sure you're very familiar with the legal test for non-compliant activities. But I think the important point is that when you're assessing objectives and policies, you need to undertake a broad judgment or a fair appraisal of the objectives and policies as a whole. And this requires more than just isolating out 1 or 2 policies with which the activity is contrary. And I make that point because in my submission, that is what the opposing submitters have done in their evidence. And the word contrary contemplates being opposed and makes it different, opposite, or repugnant to. If a proposal does not comply with the plan, it does not necessarily mean it is contrary. There must be some element of opposition apparent from the policy and objectives of the plan when taken as a whole. And the nature of a non-compliant activity means that it is unlikely to find direct support from any specific provisions of the plan, but an absence of support does not equate to the activity being contrary to these provisions. And Mr. Giddens' evidence and assessment of the objectives and policies is not only is this proposal not contrary to the relevant objectives and policies, but it does in fact, perhaps quite unusually, find quite a degree of support from them. At paragraphs, back to my lengthy submissions. Paragraph 72, I've set out the law on precedent and plan integrity. I'm sure you're familiar with that. I don't think I need to take you through it.
I think so.
So paragraph 79, effects. I think the key effects of the proposal relate to traffic, heritage, noise, and cumulative amenity effects. I've set out paragraph 80, the permitted baseline, which I've just summarised. I'll just note at paragraph 83, Ms. McConnell's assessment. She agrees that the permitted baseline includes consideration of 14 temporary events, although she says that this is minimal in the circumstances, but she's seemingly overlooking or having insufficient regard to the fact that each event could involve 500 people and last for 3 days. Of the 3-day duration, Ms. McConnell states that this is fanciful because there's a rule in the transportation chapter which would require parking areas to be sealed. However, this rule doesn't in fact apply because under 35.3.2.3, temporary events are exempted from the application of the transportation chapter. So she's disregarded the permitted baseline on the basis of an erroneous interpretation of the plan. She also discounts the possibility of longer temporary events because the proposed fence would be required to mitigate noise, and this could not be constructed without obtaining resource consent under the heritage chapter. However, the fence is part of the current proposal and would not be required under permitted events or for events permitted under Chapter 35 as part of the permitted baseline. In fact, under the permitted baseline, 21 event days, so that's could occur in outdoor area 1 with no fence and no applicable noise limits, being an important and very relevant point with regards to the baseline, which Ms. McConnell has misunderstood and not accounted for in her evidence. So just to expand on that, coming back to the sites, the outdoor area 1, along with the farm building and the stables and cow byre, all on one site. And so under the District Plan, Chapter 35, permitted rules, it would be open to the applicant or any landowner to host 7 events there in Outdoor Area 1 as a permitted activity, each of which could be 3 days long, with no applicable noise limits and with no acoustic fence.
And they could host that until 8 o'clock at night or 10 o'clock at night?
8 o'clock at night, but could undertake pack down after those hours, and the noise limits would not apply until 10 p.m. Paragraph 86. Ms. McGonnell then disregards the baseline entirely on the purported basis that if the proposal is for a commercial activity, then the temporary events baseline is not applicable. This is, of course, incorrect. The baseline concerns what can be done under the plan as of right for the purposes of assessing the effects of a proposal. How the proposal is framed is not material to the assessment or applicability of the baseline. It is instead the effects of the proposed activity that are relevant. In this instance, the effects of permitted temporary events and the proposal are clearly comparable, and the permitted baseline should be properly considered. So I guess there are a number of errors in Ms. McConnell's assessment of the permitted baseline, and that has meant she hasn't applied it at all, and really is very relevant in this case.
You would agree that it remains a discretionary act,
yes.
At our discretion whether or not we wish to apply it or we choose to apply it.
Yes, you do retain that discretion, but in my submission it will be appropriate to exercise it and to apply the baseline in this instance. So paragraph 87, Ms. Tate, for the submitters in opposition, agrees with Mr. Giddens' summary of the activities that constitute the permitted baseline and their relevance, but she considers 14 event days as a more realistic baseline than the 42 event days identified by Mr. Giddens. And just to interpolate there, the 42 event days have been arrived at because you could have 14 events across the site property, each of which could be 3 days. So we get to 42 event days as the permitted baseline. But Ms. Tate considers that you should not look at the property as 2 sites, and you should look at it as 1 site, because she says that's how it generally operates for events. That's not how it generally operates for events, and Mrs. Buckham or Mr. Buckham will give evidence about that. It operates as 2 separate sites, and it can quite comfortably do so, as often events are held at an individual location on the site. And the fact that Ms. Tate has made this assumption is quite surprising, given she hasn't actually visited the site herself, nor has she made any inquiries of the Buckhams as they undertake events. And so Mr. Giddens will take you through the permitted baseline in more detail. But in my submission, to sum up, it's relevant here. Traffic effects. Mr. Bartlett has prepared a transportation assessment filed as part of the RFI response and also subsequent. And Mr. Hewland for the council has prepared a memo. And these 2 experts are in agreement that there is ample capacity in the roading network to accommodate all temporary traffic. Access to and on-site parking for events can be suitably managed, including for evening events. There is ample capacity on-site to accommodate all parking requirements, and access to the property for larger vehicles can be adequately managed. So there's not really anything, if anything, at issue between these 2 experts. And the conclusion Mr. Bartlett reaches is that the transportation effects would be minor or less. The submitters in opposition have not presented any evidence. However, Ms. Tate considers that further information should be provided by Mr. Bartlett with respect to the property's capacity to accommodate event parking if more than 10 staff are required for an event, and if there is a conditioned requirement to avoid parking within a specified distance of protected trees. And just interpolating here, I assume her concern is that if these requirements were in place, there might not be adequate room on site to accommodate all car parking required for events. But Mr. Bartlett's assessment is actually the site could readily accommodate parking for over 200 vehicles. Not that it will be required for events, however, it demonstrates that there's ample capacity available. And Mr. Bartlett will address that further in his summary. Heritage effects. The Queenstown and District Historical Society has filed a submission that strongly supports the proposal, recognising the Buckhams as dedicated custodians of the site history, buildings and grounds. Heritage NZ has filed a neutral submission, including a request or recommendation that interpretation panels be erected detailing the site's interesting history, and that is now to be proposed as a condition of consent. Mr. Miller's evidence and his earlier RFI letter confirms that the proposal will have minor or less adverse effects and overall positive effects on heritage, and that it aligns with the objectives and policies in Chapter 26 of the PDP. Mr. Knott has prepared a report for the Council and Mr. Brown for submitters in opposition. And as between these experts, it is agreed that to ensure the long-term survival of the buildings and the continuation of the property's heritage significance, significant investment into ongoing repairs and maintenance is required. It is also agreed that it is unrealistic to rely on a private owner who is gaining no benefit from the buildings and site to continue to fund the upkeep of the buildings and the property. It's further agreed that the proposal will enable Thurlby Domain to be put to a useful purpose and incidentally to generate some income that may be put toward the upkeep of the heritage buildings and grounds, which is consistent with the ICMOS Charter. The experts further agree that with appropriate design, the proposed fence will not adversely impact any of the heritage values or the heritage significance of the buildings or extent of place, as identified in the heritage chapter, and that any impacts of on-site car parking on the property's heritage values will be negligible. Now, in relation to that last point, Mr. Knott takes a qualified position, and that is due to his confusion or perhaps misunderstanding of Mr. Bartlett's transportation assessment. And Mr. Knott appears concerned that the proposal is to provide for parking for 200 vehicles on the site. Now, that is not the proposal, and Mr. Bartlett will clarify that. The relevance of the 200 number was simply to demonstrate that there's ample capacity on site to cater for all event parking, but Mr. Bartlett's assessment is that a realistic number is 50, for a maximum capacity event is 50, parking for 50 vehicles and 10 staff. And so Mr. Knott has sought confirmation of that matter and also of the location for marquees, poolloos, potable water supplies and other facilities. And Mr. Giddens provides that confirmation in his site plan where he has identified where those facilities can go. So Mr. Knott's position is that without this confirmation, the proposal could result in detrimental impacts, and then he's gone on to reach the view that it's therefore inconsistent with the heritage objectives and policies. However, the information or the confirmation has now been provided, so Mr. Knott may wish to reconsider his position on that. And what I would say is that where he's got to is quite challenging to understand, given all the benefits that have been identified. So I think you need to approach his evidence on that, despite the qualifications, with some caution, and I guess really look back and at where the agreement has been reached between the experts. Paragraph 108. For the opposing submitters, Mr. Brown records that there is nothing in the proposal from a heritage perspective that cannot be managed to avoid risk of impact to or damage to the heritage buildings. That is, there is managed by conditions of consent. I'll just go on to say a bit more about Mr. Brown's evidence, but I'll take that as read because I think the important point is that really he's accepting that any residual issues can be dealt with by consent conditions. Ms. Tate, now she, for the planner for the submitters in opposition, she also expresses a view on heritage matters, although this is not informed by any of the heritage evidence. Her view is that in order for the heritage effects to be acceptable and the proposal consistent with Chapter 26, it should be conditioned whereby a portion of any revenue from temporary events must be put toward maintenance of the buildings and the remedial works identified in Mr. Miller's evidence undertaken before the consent can be implemented, which works should be bonded to the sum of $250,000. She doesn't provide any cogent reasoning for this or why it's necessary to achieve consistency or to not be contrary to the objectives and policies of the Heritage chapter. And in my submission, her position is unreasonable and without merit because the work she requires to be undertaken neither fairly nor reasonably relate to, nor are they logically connected to the proposal. The remedial and maintenance work she references are and will be required regardless of whether this proposal is consented and proceeds. They arise due to the age of the buildings, not the proposal to utilise the property for temporary events. The more significant remedial works that Ms. Tate states should be bonded under the consent relate to buildings that are not proposed to be used for temporary events, further reiterating the points I've just made. And as a matter of law, conditions that have no logical connection to the proposal, such as those promoted by Ms. Tate, are unreasonable and cannot properly be imposed. And Mr. Miller's summary evidence will explain that he has not come across this approach previously, and that in his view it is inequitable and unreasonable. And just to build on that, I think it's completely unwarranted in the circumstances where Mr. and Mrs. Buckham have a demonstrated history of being custodians for these buildings and caring for them, and expending significant sums of their own money to restore and enhance their heritage. Ms. Tate's recommendations could be seen as penalising them for this dedication, remembering that the property is only listed due to the works that the Buckhams have undertaken. And on my conclusion, on my submission, on any properly considered and objective assessment of the proposal, which does not propose or require any modifications or alterations to the buildings or grounds, facilitates the maintenance and upkeep of the buildings through their economic use, facilitates public and private access to and appreciation of the heritage buildings and grounds, is plainly wholly consistent with the Chapter 26 objectives and policies, and results in positive heritage effects. So paragraph 118, noise effects.
Sorry, Ms. Orr, can I just ask you a question? So your 117B, you say facilitates the maintenance and upkeep of the buildings for economic use. And I realise that there's a big gap between what Ms. Tate is suggesting and this, but there is some middle ground somewhere there. The Buckhams are clearly in, or my reading is that they are intending to use those funds to some extent for this, and you've submitted that at 117B, and yet you've suggested that Ms. Tate's comments that the funds be put aside to maintain the buildings are unreasonable.
Well, yes, and that is because the works that she's saying need to be undertaken are for buildings that aren't part of this proposal. They're not proposed to be utilised for temporary events, but also because the maintenance and upkeep is not caused by this consent. It is.
I understand that. I guess my question is, how can you promote under 117B that it's going to facilitate the maintenance and yet say you can't impose any conditions? And you're not volunteering any conditions, I assume, to that regard. They just
no, we're not volunteering. I don't think conditions would be reasonable at law, and nor could they properly be imposed. I think, and nor do I think they're necessary, because Mr. and Mrs. Buckham have a demonstrated history of funding significant maintenance and restoration works, and by any calculation would have expended a lot of money over the course of the 30 years of their ownership of this property. And so any income they might receive from this, from future events, bearing in mind that many of the events they propose to undertake are for community purposes and on a goodwill basis. So there's no certainty that there'd actually even be much of an income from the use for temporary events. But
so B is really a bit empty.
No, I don't believe it is, because the point is that the Buckhams have, as I've said, expended considerable sums in the past out of their own pocket. Any income that might be received might go towards offsetting to a small degree those costs, but they would certainly not be compensating them or for the future works that would be required. Of course, it's open to the Buckhams to do nothing with these buildings, in which case they could decay and be lost forever. And that is I think a very something that needs to be considered if this consent is to be declined.
Well, that I suppose that's my point, is what certainty are we getting that this consent will actually assist that?
Well, I'm not saying you need certainty, because it's a benefit of the proposal, but it's not part of it.
It's not a certain benefit, though.
Well, I think under the Buckham's watch it is, but I don't think you need to condition it, and nor would it be appropriate or reasonable to do so.
Okay.
Thank you. Shall we move on to noise effects, please?
Yes. So paragraph 119, it's generally agreed between Mr. Hay and Mr. Exeter for the council that the proposed mitigation measures for noise from temporary events will be effective at reducing noise emissions and effects. Noise from temporary events at all proposed locations will comply with the applicable district plan daytime noise limits. Noise from evening events in the stables will comply with the applicable noise from evening events in the stables will comply with the applicable nighttime noise limit. However, noise from evening events in the farm building may not comply with the applicable nighttime noise limit where music is played at the maximum proposed level, although the LMAX standard would still be complied with. It's also agreed that for evening events, the potential adverse effect of noise is annoyance up until 10 p.m, after which it is sleep disturbance. And I just note that since Mr. Exeter prepared his assessment, the proposal has been further refined, including the removal of events at the ruins at night time and some further restrictions on daytime and nighttime activities in terms of event duration and so forth. And these Mr. Exeter may wish to take these into account and considering whether he needs to update his assessment. But the point is that regardless, there's not really much at issue between Mr. Exeter and Mr. Hay. And where we're sitting is full compliance with the PDP daytime noise limits for all events at all locations, resulting in less than minor adverse effects, and non-compliance with the Buckham Basin Lifestyle Precinct nighttime noise standard at some neighbouring site boundaries on some occasions, but maintenance of acceptable levels of amenity at all nearby dwellings within the precinct and at all sites within the amenity zone, resulting in no more than minor effects. And I just speak to this next part of my submissions, and it's really a technical matter for Mr. Hay to elaborate on. My understanding of the evidence is that Mr. Exeter has applied an annoyance level. So, when assessing effects, he's applied some World Health Organization guidelines which indicate that the onset of moderate annoyance may occur at a noise level of 50 dB, averaged over 16 hours, and he's and this is in his table. He's assessed the level of effect with reference to these WHO guidelines, but he's also introduced a new measure which isn't in the WHO guidelines, which is something less than a moderate annoyance, and it's a slight or mild annoyance. And what Mr. Hay has said of this approach is that, well, it's that in terms of the moderate assessment that's accepted, the slight and mild annoyance, that's something that Mr. Exeter has come up with. But in any case, a moderate annoyance effects equates with a minor adverse noise effect, and a mild to slight annoyance equates with a less than minor adverse effect. And I don't think there's any real debate between the experts about that. Now, Ms. McConnell unfortunately appears to have misunderstood Mr. Exeter's evidence, and that she's equated a moderate annoyance effect with a moderate adverse effect, but that's, as Mr. Hay explains, not in fact correct. And unfortunately, that has then influenced her assessment of the effects and of the related objectives and policies, the noise objectives and policies. So having heard, or once she hears Mr. Hayes' evidence, and she may wish to reassess her position on those matters. And of Mr. Trevathan's evidence for the opposing submitters, I note that he doesn't take issue with any of this. He just raises some concerns about some uncertainties in Mr. Hayes' evidence and how some assumptions he might have made when reaching his conclusions, seeks further information on those matters, and Mr. Hay will provide that when he gives his evidence today. So at paragraph 131, all in all, there is very little, if anything, substantively at issue between the experts with regards to the noise effects of the proposal. Cumulative effects, and this is really, I guess, the key issue here, at least from the submitter's perspective. Putting aside Ms. McConnell's assessment, which contains errors, planners appears to be the potential for adverse cumulative effects. And at paragraph 134, I've set out what the Act says about those. And at paragraph 135, that they are effects arising over time and effects arising in conjunction with other effects. Paragraph 139, Ms. Tate's assessment that the proposal fails to pass either gateway test is underpinned by her assessment of potential cumulative effects. Her view is that while individually the adverse effects of the proposal are capable of being remedied or mitigated to an acceptable level, i.e. minor or less, when considered cumulatively, the individual effects which she identifies as noise, servicing, and the presence and location of buildings on site result in the sum being greater than its parts, and the effects on amenity values, particularly those of 67 Speargrass Flat Road, are in her view more than minor. She also considers that the cumulative effects of using the site for 100 events plus 60 permitted filming days are more than minor. Ms. Tate refers repeatedly throughout her evidence to the intense and persistent nature and constant throng of the proposed activities and the non-fanciful potential for the property to be used every day for 6 months of the year without respite. She does not articulate which aspects of the proposal she considers will be intense, however, and it is difficult to conceive of any that will, particularly given the agreement between the noise experts that the noise effects of the proposal will be minor or less. She sets out a long list of various activities that she purports will result in a constant throng of daily activity, but she does not articulate with any detail the nature of the effects arising from these activities, if they were to occur on the basis she assumes, which they will not, nor how, why, or for whom they will be adverse. With regards to the purported persistent nature of the proposal and its effects and the constant throng of activity, a significant underpinning of Ms. Tate's view is that her assumption that all events will occur within a 6-month period, and that's November to April. All events will require a separate setup and pack down day. All events will be at full packs of 150 guests. All events will have catering and music, marquees and portaloos, and all events will run for the maximum permissible time of 6 hours. Her assumptions, however, are at odds with the purpose and the intent of the proposal as described in the AEE and in the evidence of Mrs. Buckham, which is to share and utilise the property without modification except in the fence, for mostly low-key gatherings by community groups, schools, charities, recreationalists, and for picnics and photography, as well as for private uses such as wedding ceremonies, which are by nature also generally low-key and quiet affairs, and which can provide some revenue to offset the ongoing maintenance and repair costs of the property. If I just take you now to my summary, because I think I say a bit more about Ms. Tate's evidence, which might put some perspective on it.
Which paragraph is that?
Paragraph 59.
59. Yes, got you.
Actually, in fact, I'll start at 16. So when undertaking her assessment of cumulative effects, Ms. Tate has made a number of rather extreme assumptions about the level of use of property, the type of temporary events it will host, and the nature of the guests in attendance. There are, for example, repeated references to hyped up and intoxicated guests and the likely intense and persistent nature of events. as I've just alluded to. These assumptions are surprising because they cannot reasonably be drawn from the proposal itself, including the manner in which it was presented in the AEE, nor from the evidence filed by and on behalf of Mrs. Buckham. This evidence discusses community events, school, church, recreational groups, and so forth, and wedding receptions, but indeed provision is sought for only 12 evening events per annum, which is when wedding receptions might occur. So no persistent nature there. Photographs are included in the AEE, which illustrate some of these uses. They show low-key, quiet, and sophisticated affairs, not large groups of hyped up, unruly, and intoxicated guests. Many more photographs of past events are available through an online search under the property's common name, and I just invite you to actually Google Thirlby Domain, and you will not see events with unruly and intoxicated guests. And so Ms. Tate's assumptions are not borne out by the evidence or the previous use of the property. Ms. Tate's evidence is given on behalf of the Buckham's immediate neighbour at 67 Speargrass Flat Road and others. But as I've noted, the focus of her evidence is on the assessment of effects on this neighbour. This neighbour has made a submission on the proposal. The submission is highly emotive and contains many unfounded and untrue inferences and allegations about the Buckham's behaviour and intent. The Buckhams have not saw fit to respond to or address this in any detail to date, on the understanding that the allegations made are not of any relevance to the Commission and its decision. However, upon reading Ms. Tate's planning evidence and the assumptions she has made about the nature of the proposed temporary events and the types of guests they will attract, it appears that her assumptions are based on others' extreme and apparently highly sensitised perceptions of the Buckhams in the proposal, rather than on any objective and balanced assessment of her own. And without delving into the detail, unless the Commission considers it will assist, in which case Mrs. or Mr. Buckham can elaborate, Mrs. Buckham advises that there is a history between the Buckhams and the neighbour at 67 Speargrass Flat Road that is unrelated to past or proposed temporary events at Thirlby. This history has clearly influenced the tone of the neighbour's submission. For example, the inferences and allegations about deliberate invasive boundary planting, arsenic-tainted water, unruly behaviour, and a disregard for her concerns. As Mrs. or Mr. Buckham will explain, there is no truth to any of these inferences or allegations with regards to both past actions of the Buckhams and the nature of temporary events undertaken on their property to date. The point to note here is that others' perceptions of the Buckhams and their activities appear to have influenced Ms. Tate's perception of the proposal and consequently her assessment, albeit possibly inadvertently. The unfortunate upshot of this is that Ms. Tate's evidence makes extreme and unrealistic assumptions about future use, and in doing so lacks measure, balance, and perspective. Now, if I just go to paragraph 148, notwithstanding what I've just said regarding the somewhat hysterical nature of the submissions and the evidence, particularly about the potential for adverse cumulative effects. To address the concerns about potential cumulative effects, further conditions are now proposed that limit the length of any temporary event, as we've discussed, to 6 hours, limit the number of evening events that can occur per week and per month, and provide for a considerable or for a lengthy period of respite between events, limit the number of temporary events that can occur at any one time, including any temporary filming event, limit the number of events and persons in outdoor area 1, and prescribe discrete locations for portaloos and other servicing facilities. And Mr. Giddens will address these further. And these measures will ensure that any potential adverse cumulative effects are minor or less. Objectives and policies. As I've previously stated, and as you'll be aware, what is required here is a fair appraisal of all relevant objectives and policies. And if I just summarise my submissions here, Mr. Giddens appraised all the relevant objectives and policies. Ms. McConnell has endeavoured to do so, however, due to the errors contained in her other parts of her assessment, her objective and policy assessment is not that robust. But Ms. Tate has cherry-picked the objectives and policies under which she assesses the proposal. She contains very scant discussion of the heritage objectives and policies under which the proposal clearly finds significant support. And she's also jumped to conclusions that the proposal will be contrary to the Chapter 24 objectives and policies, with their focus on maintenance of amenity values, despite the agreed position on noise, that noise effects will be minor or less, or maybe less than minor, and also on the basis of her overstated assumptions about the actual use of the property and cumulative effects. So I think you need to approach your assessment of the objectives and policies with some caution. Other matters, precedent effects and plan integrity. I've set out the law earlier and you'll be aware of it. Ms. McConnell and Mr. Giddens both agree that there's a low risk of either precedent or plan integrity issues arising here. Ms. Tate takes a contrary view, and she does so on the basis of what she describes in the evidence as a brief review of the district planning maps. And on that, on the basis of that very brief review of the maps, she's concluded that there is a real risk here of precedent effects and plan integrity. And to my submission, that just cannot stand, particularly when you look at the particular characteristics of this proposal and the site itself, including, and I set these out at paragraph 165, its multiple locations, multiple buildings and locations suitable for events, the layout of the property with its two accesses and ample capacity, ability to accommodate all required parking on site, its unique history, including its past and current use for temporary events, the ability to utilise the property and buildings without alteration and modification, its established vegetation that screens much of the property and events, and the ongoing residential use of the property with the consent holder able to reside on site, as well as the significant ongoing maintenance and upkeep costs of the heritage buildings that the provision for temporary events will support. And in my submission, these are all material factors, all of which together would be difficult to replicate on another site. And in earlier in my submissions, I've noted the court's comments that actually issues of plan integrity, in fact, seldomly arise, and non-compliant proposals must be assessed under the provisions of 104D, and if they pass either gateway test, then it's appropriate that they be granted. And building on that, at paragraph 70, I say that if
you just say it's appropriate that they be granted if it passes the gateway test.
A non-compliant activity.
Yes.
Well, it is open. I reframe that it's open for the
Okay.
But what I would say, and this is really it's not something I'm placing any weight on, but if a precedent were to be set here, and I don't consider it will, would it be a bad one, where the proposed entails the adaptive reuse of a Category 1 heritage listed property involving no modifications or alterations, and provides an economic use that facilitates the property's restoration, upkeep and maintenance, ensuring endurance for future generations, and where the environmental effects of doing so will be minor or less. In the next paragraphs, I've addressed the best practical option because Ms. Tate and Mr. Trevathan suggest that that's something that ought to be considered in respect of outdoor area 1, and that it would be consistent with the BPO to not include that area in the proposal at all. I've just set out why that would be wrong, or at least not justified in this circumstance. And I also note that further restrictions on the use of that area are proposed in any case. Effects on property values. Some submitters have raised these in their in their submissions. Well established that these are not relevant environmental effects. Community perceptions. I've noted there that some of the opposition is very strongly expressed to the proposal. As I've said, it's quite emotive for some submitters and includes unfounded and erroneous allegations about prior or future conduct of the Buckhams, seemingly with the intent of slighting or impugning their integrity. Any allegations, this is paragraph 179, or suggestions in this regard are not accepted and are strongly refuted by and on behalf of the Buckhams. They are without foundation, nor are they of any relevance to the assessment of this proposal. And this includes express comments or inferences regarding a history of non-compliance by the Buckhams that is just simply not borne out or true. Security concerns, which are unfounded. Rubbish in the road reserve due to previous events, which is unfounded and untrue. Arsenic in the potable water supply.
We probably have understood this. We can probably take this as read.
Thank you. And just on amenity values more generally and how the community might perceive those, I think the important point to note is that what is required here is an objective judgment. And perhaps if I read out the quote, or you read the quote at paragraph 183 about what the courts have said about subjective views of amenity, that they might factor in the decision, but ultimately the decision on whether effects on amenity would be adverse must be an objective one. And it is to be informed by the district plan and what that says about amenity, and the permitted baseline can be relevant in that regard. So almost at sum up, but there is one further matter that has become apparent since filing those legal submissions, and I touched on it in my summary, and that is at page 48, and it is non-object covenants. We have just very recently ascertained that 4 of the opposing submitters are subject to non-object covenants which are registered against their title. Those covenants expressly preclude the lodging of a submission or bringing of any proceeding or claim against commercial activities, which include activities of the very nature addressed by this proposal. Not only that, the covenants contain a clause which provides for the deemed written approval to any such proposal. And I'll provide you with a copy of the covenant and the relevant titles.
Thank you.
As I say, I'll just take you to the law. They're registered on the title, they remain relevant, and they relate to 86 Speargrass Flat Road, 88 Speargrass Flat Road, 90 Speargrass Flat, and 92 Speargrass Flat. And the courts have previously considered the legitimacy of these types of covenants in the RMA sphere, and they've found that they do not contravene the purpose and principles of the RMA, nor are they illegal, and that it's open to the public to waive their rights of participation in the RMA. The courts have further found that they are binding, and in a local decision, Homeburn Planning and Queenstown Lakes District Council, the Environment Court, when considering the effect of a deemed written approval clause in a non-object covenant, found that it was sufficient for the decision maker to simply see that covenant and to take that written approval as properly given under the RMA.
So I'll just clarify, going back to the list of submitters in Ms. O'Connell's evidence in her paragraph 9, her appendix 9, we're talking about which ones do you say this is related to? Just using her numbers, just if I can, for simplicity. Are we talking 23 and 25?
Let me just, I've noted in paragraph 50 of my summary, I'll just double check that I have that right. I have noted as submitter number 1.
Submitter number 1. Oh yeah, gotcha.
And that relates to 2 properties. That relates to 86 and 88 Speargrass.
Yeah, yes, got those, yes.
Submitted number 5, that's 90 Speargrass. And submitted number 21, and that's 92 Speargrass. And those parties are Speargrass Holdings, which is Chris and Michaela Meehan, right. Kerry and Joanne Purcell, and Rebecca and Edward Evans. And right. So in my submission, and the law supports was clear on this, not only must you disregard their opposition, but you must deem that they have given written approval to the proposal, and you therefore must disregard any adverse effect on that. And
you'll be sending that copy of those covenants through to us, yes?
Yes, I will.
So, okay, thank you.
So in summary, the proposal for temporary events at Thirlby Domain has been refined and is now of a much lesser scale than when it was notified and submissions made. The refinements have been made in response to matters raised in submissions and by the Council in its RFI and Section 42A report. The refinements result in a proposal that has minor or less adverse effects and significant positive effects. The primary positive effects are on historic heritage and values. Historic heritage is broadly defined in the PDP to mean those natural and physical resources that contribute to an understanding and appreciation of New Zealand's history and cultures. Enabling the property's use for temporary events will contribute to the understanding and appreciation of its significance and importance in the history of the district. It will also provide an economic use for the property, which will facilitate the ongoing maintenance, upkeep and restoration of the heritage buildings, protected trees and grounds, the cost of which is significant. Numerous submissions have been filed both in support of and opposition to the proposal. The supporting submissions generally acknowledge the unique character of the property and its special values and support its use for temporary events as a means by which to enable more people to learn about, experience and enjoy its heritage. Supporting submissions include those by current or prior neighbours who record they have experienced no adverse effects arising due to previous temporary events. Submitters in opposition are generally concerned with how the proposal might affect the enjoyment of their own properties and amenity. There is an element of hysteria in some of these submissions, which unfortunately is reflected to some extent in the submitted evidence insofar as it lacks measure, perspective and balance. There is some dispute about how the proposal should be classified, whether as a temporary event, a commercial activity or something else. No matter the classification, the proposal falls to be considered as a non-compliant activity and has been assessed as such with all relevant effects and objectives and policies accounted for. The classification of the activity is of no impact on the outcome. This is not a case that is finely balanced. The proposal readily passes both gateway tests. It is instead a case about consent conditions. Consent conditions have been proposed on behalf of Mrs. Buckham with the intent of addressing and appropriately controlling all potential effects in a manner that is readily ascertained and enforceable. It may be that further refinements to the conditions are required in order to ensure that the intended outcomes are achieved and potential effects appropriately managed. Inevitably, further refinements will be made as the issues are discussed during the course of this hearing, and I just emphasise that Mrs. Buckham is open to any direction that the panel might have on such matters. And those are my very lengthy opening legal submissions. Thank you for persevering. I didn't anticipate having to deal with 45 pages, so I'm sorry to have.
No, it's all good. Thank you. It's very good. So, Ron, just going to have any other further questions?
I do have just a couple of questions. At 137, you said the law is unsettled as to whether a cumulative effect must be one that arises as an effect of the application for which it's sought, or whether possible permitted uses can also be considered. And you've referenced 2 pieces of case law. Have you provided those cases? I
haven't provided any cases, but I can if you'd like me to.
Yes, I don't want you to provide all cases, but those 2 would be interesting, please.
Yes, one is the Dye case, which I haven't actually given you a full reference for. Sorry, that's the new case, and it's older, but it is establishes a number of legal principles. And the other case is a later Environment Court case of Judge Jackson. So yes, I can provide you with both cases.
That would be helpful. Thank you. At paragraph 142, yes, this is where you have refuted Ms. Tate's assessment of what may occur on the site, and you have said which they will not. Now, while I take your point that she may well be going into the extreme end, what is there actually in this consent that is stopping?
Well, there are now conditions that limit the regularity of the use. So her assumption is that you're going to have, over the summer months in particular, you're going to have an event every day. Not only that, every event is going to have a full day set up at a full day packed down.
Yes, that's now changed. Yeah.
So we now have conditions, and Mr. Brett will take you through these, that limit the amount of events you can have per month, per week, and on consecutive days. So her extreme concerns in this regard have been dealt with.
Right. Okay. Understood. No, thank you, Ms. Holt.
So just for me, so I can get my head around this. So the management, and particularly there's so much stuff, and it is, as my colleague is saying, it's as you said, it's changing. So the management of the actual activities, and I totally take Ms. Buckham's point in her evidence that she says that as consent holder should be responsible for these. But the day-to-day management of the conditions and the setting up and all those sort of, the actual activities, if you like, they're going to be managed by the company or whoever books the site for better uses of words. Is that correct?
Well, that might be something that Mr. Giddens can better assist you with. I think it'll probably depend on the event, but the way this has occurred in the past, and recognising and accepting that there needs to be a greater level of oversight potentially with some future events, is that the wedding companies, for example, they come in and they do the lot. They have staff, they have all the equipment, they bring it all in, and they deal with the whole event. And if that type of situation was to continue here, there would be a detailed set of operating procedures, and which would encapsulate the consent conditions, which would be provided to these companies prior to using the property. And these companies are regular users of the property, so they become, they'll be aware of the property's constraints, if you like, and consent conditions. And so it might be that on the ground for any given event, they're actually dealing with things, but the Buckhams, as the consent holder, will of course ultimately be responsible for compliance and will need to adopt a level of oversight, and certainly will be responsible for ensuring that people hiring the property or using the property are well aware of the conditions and the operating conditions, and that they comply with them. And there's there's an easy way of regulating that, is if people don't comply, then they don't come back.
So it's a bit like, in a way, in essence, it's a bit like hiring a council hall, isn't it? You hire it, you get the terms of conditions, and you hire it on that basis, and then you comply with the conditions, and off you go, type thing.
Well, to some extent, yes.
Yeah. Okay. I'm just trying to get my head around. So, as I say, I'm just trying to give myself an analogy. So, if you could hire a council hall, the council provide, or a community hall, for better use of words, has all the conditions. You hire it, you're responsible for meeting those conditions, and then you pack up and go, type of thing, just as you would for a community hall or a council hall. Yes,
and it could be practically to provide, I guess, some assurance to the Buckhams, but also ultimately to the council that, for example, a bond might be entered into, and so that that hasn't occurred to date, as I understand it, but where the person hiring the property pays a bond, and if they don't do what they need to in terms of removing equipments and so forth, the Buckhams can come in and do it at their cost.
I mean, it's just like hiring, community hall. Okay, thank you. Just in terms of and maybe something to pick up with Buckham as well. It's just, I think we're just trying to be clear in exactly actually what we're, if we came to a view to consent, what we're consenting, and how do we ensure that Ms. Tate's concerns don't take out? Because I take your point. It's really, this is what you're asking for is a low key weddings. I don't know. It's not, shall we say, for better use of words, allow 21st birthday parties. What we're talking about here, are we?
No, that's not that. I mean, it's the property, as you will have seen when you went there, it has quite a different appeal. It's it's not somewhere where you go to hold a big boozy party. It's somewhere where you go to have a really sophisticated, classy affair.
I suppose the question, and that's the thing I'm just trying to get from my mind, is how do we ensure it doesn't turn into the point about a boozy party or allow 21st and all those sort of things, and how it doesn't morph into something like an event centre or anything like that. It's just how do we keep it at that low key thing, which I suppose that's the point I'm just grappling in my mind, and I'll have to give it some thought, but just how we do that, I suppose.
Well, Mr. Giddens, I'm sure they'll assist you on that and you look at consent conditions as a whole. So we've got noise conditions and which are now we are proposing noise limits, and so you can actually go out and measure, are you compliant or are you not? So really readily enforceable noise limits. We've obviously got operating hours as well, which are everything's got to wrap up, well, mostly at 8 p.m. or 12 events at 11 p.m. but there's also a requirement for a noise management plan and an operational plan, I believe, or that might be encapsulated in the noise management plan, and that will set out and deal with a lot of these matters. That needs to be provided to the council, that can be reviewed, and there's also a complaints procedure in that, and what needs to be done if complaints are received. So there's a lot of self-regulating in there, but there's also the ability for the council to have some oversight through the certification for the noise management plan and the review condition as well. And of course, that provides for the consent to be reviewed to deal with any effect that was unforeseen at the time the consent was granted.
So that's a 1 to 8, and you're offering that sort of on a no-issue basis for an ongoing process, not time limiting that?
No time. Correct.
Okay, so it's just so if there's no, because I'm just a bit hesitant with 1 to 8 if you're not offered on a no-issue basis with the ongoing forever type thing, but you're offering us that sort of that basis.
I believe so. I think Mr. Perhaps if you speak that through with Mr. Giddens, and those consent conditions were just provided to you this morning.
Yes.
Is it an annual review? It's an annual review condition.
Yeah, I'm just trying to find it now. Oh, find it. Here we go. I'll review. Here we go. Within 10 working days. Okay, I'll read this. Okay, no, you've clarified my point. You've offered them to us. Okay, thank you.
And so B, 42B there of that condition, of course, provides the council with the ability to review on the basis of any to avoid remedy or mitigate any adverse effect. Well, that's changed circumstances perhaps, but I think that the review condition is framed broadly enough that if it turned out that this consent was playing out in a way that is quite different to how we've presented it here, that the council could come in and review it.
Okay, I think maybe, as you say, we could potentially think about that, but I'm just clarifying as a concept, that's where you confirm that by giving us these. Okay, thank you. I think that's all I have, unless there's anything else you'd like to?
No, thank you.
Okay, we were thinking of taking the break at 12:30. Shall we start? I assume in terms of the order of your witnesses, that we go as you set out in paragraph 27 of their full submissions, beginning with Mr. Hay, then off to Mr. Bartlett. Is that correct?
No, I was going to have Mr. Giddens go and take you through the consent conditions first. So Mr. Giddens to present his evidence in 2 parts, if you like. So to take you through the consent conditions so you're clear on what they are and where the proposal now sits when you're hearing the noise evidence. But I actually, Mr. Giddens is standing here ready to go, but I just wonder whether I might deal with Mr. Bartlett first, because it's probably about 1 a.m.
I was just about to say he's back there. He's obviously, maybe he's got an invite to Her Majesty's funeral. Maybe that's.
Well, he might do, and I wouldn't want him to miss out on the opportunity.
Miss out on that. So,
yeah, it's only a once in a lifetime thing. So, and there's really, I don't think anything in the traffic evidence. So if he presents a summary, and then you can ask him any questions, and then we'll.
Seriously, we don't want to hold him keep you up too late at night.
Yes, and then we'll get on to Mr. Giddens.
Okay, thank you. So, Mr. Bartlett, you there?
I am here, Commissioners. How are you?
All right, how are you today?
Good, thank you. Good. And no, I probably won't be going to the funeral.
All right, I assume you're on holiday, and anyway, seriously, let's move on.
Yeah.
And thank you for making the time to come at such a late time of night. So, do you want to take, as we've seen you before many times, so we take 1 through to 7 as read and move on to number 8, please?
Not a problem, yep. So in my evidence, I've considered the traffic generation and parking, including guest, staff and event-related vehicles for a maximum 150 guest event at the site. This has guided the assessment of on-site car parking and access to the site from the adjacent Speargrass Flat Road. My assessment considered that for a maximum event, there will be a demand for up to 60 vehicles to be parked on the site, allowing for 50 guest vehicles and 10 staff and service vehicles. To further clarify, this is what I expect a maximum event, with the actual demand varying considerably from around 20 guest parks for events of around 30 to 50 guests to around 35 guest parks for events of 75 to 100 guests. This proposal will make use of the existing accesses and will provide on-site parking within the site. A number of consent conditions are recommended to specifically manage on-site car parking and access within the existing site environment. On-site car parking is proposed within the existing landscape. The site is large and has the ability to accommodate over 200 parked vehicles within the site. In light of some of the assumptions made in the submitted evidence, particularly from the heritage assessment, it is important that I clarify that parking of 200 vehicles is not proposed or expected as part of the proposal. Rather, my point is that the site is large and has ample space to accommodate parking in numerous areas of the property. The benefit of this is that where an area may be unsuitable, say from rain or others, and becomes wet and muddy and whatever else, then alternative parking locations can be easily used. I consider that any site access and parking matters can be effectively managed through on-site management as required by the consent conditions proposed by the applicant. With these measures in place, I consider that the potential transport effects and road safety concerns arising from the proposal will be minor or less. Since I prepared my evidence on behalf of the submitters has been lodged. I have reviewed the submitted evidence, in particular the planning evidence of Susanna Tate, who raises concern with respect to transport and traffic. Ms. Tate suggests that additional staff parking may be required for 20 staff based on what appears to be a formal wedding type event. I acknowledge that each event will be different and will result in different parking demands for staff guests for specific events. Again, that what I have presented is what I consider to be a realistic yet robust worst case maximum sized event. I would expect there to be a mixture of event types and sizes, with smaller events having considerably less parking, less traffic generation and parking demand. I consider 20 staff for a maximum 100-person event to be unlikely. My expectation is that the allowance of 10 staff / service parks allowed is realistic for larger events based on other similar proposals and activities in Queenstown area. The consent conditions allow for flexibility in parking and require that the consent holder is to manage on-site parking, regardless of any specific event, whilst the overall site area allows for considerably more car parking than will be required for any one event. Ms. Tate also notes that parking should also be set back from trees, paragraph 65, and heritage elements of the site from Mr. Brown's heritage evidence. To understand that a condition to this effect is proposed by Mr. Gibbons. Sorry, I didn't read that very well. My estimate of overall parking capacity assessment is, in my opinion, robust and is based on parking layouts at other similar sites in Queenstown and Arrowtown, where allowance has been made for buildings and mature trees within parking areas. And I would add there, these are informal car parking areas, so they're not sealed or anything, they're just grass parking areas as well. I consider that requiring the suggested setbacks for trees or heritage items within the site will not noticeably change the overall parking capacity calculation of more than 200 parked vehicles being able to be accommodated within the site. Capping the event size to 150 maximum guests results in 50 guest parks, meaning that there is ample ability to work around heritage trees and buildings and to tailor temporary parking areas to meet the requirements of specific events. I note in my 30th June assessment that outdoor events at the site are less likely to occur in the colder, wetter months. To clarify, this was an assumption on my part to demonstrate that the overall area of the site available for parking is sufficient to allow for event parking, including during the colder, wetter months. It appears in the submitter evidence that this comment has been used to run with the assumption that all events will be concentrated within certain months of the year. Any site constraints as a result of weather and or time of the year are considered through the proposed consent conditions, allowing for management of parking within the site to avoid muddy or damaged areas of the site, which may be unsuitable for parking, particularly during or following inclement weather. In summary, nothing raised in the submitted evidence causes me to reconsider the conclusions reached in my primary evidence. I maintain the view that on-site parking and access can be appropriately managed through proposed consent conditions. Overall, I consider that the potential traffic, transport effects and road safety concerns raised by the proposal will be minor or less.
Thank you very much, Mr.
Happy
Barber.
to answer any questions, commissioners.
Sure.
Thank you, Commissioner. Mr. Barber.
Mr. Bartlett, do you have the conditions proposed by Mr. Giddens in front of you?
I do.
So from condition 28 onwards, they seem to be about traffic management.
Correct.
So I understand from your evidence, I think, that any vehicle over 8 metres in length has a problem accessing the site. Is that correct?
Using SweepPath programs, it is not tidy for a vehicle larger than 8 metres to enter the site. They can do it, but it may be difficult to get through the gateway or gateways, either gateway.
So I imagine they would be doing a 25-point turn. Is that how I imagine that?
Absolutely not that many. No, basically the gateway would be within half a metre of the body of the vehicle. So it would mean that some drivers or some vehicle types may be required to have a brief single reverse manoeuvre to realign with the gateway structures.
Okay.
And particularly the iron gateway is at the, thinking this through, Western gateway would not be suitable for larger vehicles, but the Eastern gateway nearer the stables, yeah, it may be that large vehicles, and I'm talking large coaches and that sort of thing, may find it a bit untidy, and some driver and vehicle combinations may be required to have a short reverse manoeuvre to align with the gateway structure.
Sure. So there's condition 29, which prohibits tour coaches, and there's condition 33, which requires an approved traffic management plan for vehicles greater than 8 metres in length.
Yes.
So I guess from the point of view of limiting the number of vehicles, tour coaches would generally be a good thing.
It would be. It would be a good thing, and it might mean that essentially a temporary traffic management plan might be the fact that someone might have to guide those vehicles in. They might need to consider when some of those vehicle driver combinations need to reverse, whether they can do that safely without interfering with traffic on Speargrass Flat Road. So it's just a matter of managing how that vehicle gets into the site.
The conditions as they're written, condition 29 would prohibit a tour coach.
Yes.
Do you think that's necessary?
I think it would be useful to prevent them going in, because it means that you can have one less level of management required on the site.
Okay, so then why do we have condition 33? Why is it not useful to prohibit them full stop, vehicles over 8 metres?
Well, because you might find that in the future the site accesses change, in which case it would be a lesser requirement to go through those sort of consent conditions and manage them that way. So, or you might find that a particular event, unfortunately, needs to have a large vehicle going in which case it's about how you manage that vehicle going in. And bearing in mind, there's a number of vehicles between a tour coach being at 12.6 metres long and an 8 metre truck or a smaller bus.
Sorry, how long is a tour coach?
Yeah. So a tour coach is 12.6 metres long.
Okay.
A standard tour coach. There's bigger ones. But, a large rigid truck, say, is only 11.5 metres long. A standard bus is only 11.5 metres long, whereas a smaller bus, a 20-seater bus, is 8 metres long.
Right, okay, so I probably haven't realised a tour coach was such a specific thing.
Yes, it is definitely a specific thing.
A 12.4, a 6 metre long vehicle.
Yes.
Okay.
I could go into a lot more detail if you would like.
No, that's probably sufficient for my understanding. Thank you. Condition 31, the consent order shall advise event organisers of applicable access arrangement for a temporary event.
So you might...
I mean, I guess my question on this is it enough for the consent holder to advise, or should there actually be a plan which gets, which is available, is potentially available for compliance on site? To just advise someone seems very vague.
Yes. So, okay, I understand what you mean. And I suppose it comes down to that, what sort of event it is and what sort of vehicle types might be going to access it, and where is the event going to be held on site, and therefore where would you want to put the car parking for that event on the site. So I think there's a lot of things going on there. So for instance, from what I was saying before, those larger vehicles, the 8 metre truck and a smaller bus, they are pretty much restricted to going in at the eastern access, beside the stables area there, and it's possibly where you might want to have your service vehicles coming and going from, but you might want to choose to have your cars, say, coming and going from the eastern access. So, and you might want to have them going through a specific route within the site, and I think that's where the consent holder needs to advise how that should happen, given what the site conditions might be like, and if you think you've had a week an event the week beforehand, and therefore you might have specific elements of the site that you need to work around. So I think having a structured plan would make it really difficult if you're trying to also protect the site and the existing environment as well.
So you're saying that it shouldn't be fixed because you need flexibility?
Correct.
But these conditions of consent are conditions that the council is supposed to be able to enforce. If this is some verbal agreement, I'm unclear as to how the council is going to enforce this.
Well, I suppose it comes down to sort of thinking about the site as a whole and how you want to use those specific accesses for any one particular event. If you have a plan and you have to have parking at this location, and that location somehow is affected by the weather in the past week or whatever, you then need to be able to make sure you're still providing an appropriate facility on the site.
My question to you is different though. My question to you is, what is the point of this condition in terms of managing an environmental effect, and how is the council going to monitor it?
I'm not too sure how council would monitor it, but certainly it's important to make sure that they can manage the site appropriately.
Okay. And that condition also includes the identification of the minimum setback of 10 metres from any protected tree or property on at least 2 metres. Now, to me, that seems to be a very important condition, which shouldn't be part of a plan. That should be a condition in its own right. Would that make sense? Because that's never going to change.
Yeah, I think that should be part of a condition in its own right. I would probably agree with you there. If those are the distances that are required for the heritage and the trees, that I would agree with you that should probably become a consent condition on its own.
Yes. Okay.
Nor am I. Sorry, I can't advise on heritage and mature trees and those sorts of things.
Okay. I don't have any further questions for you. Thank you.
Thank you, Mrs. Barlow. That's all from, I don't have anything more. My colleagues covered everything. Thanks very much, and thank you for making the time.
Not a problem, thank you.
You're most welcome to stay, but I imagine you're probably off to bed.
No, I think I might go to bed just in case I want to probably go and do something else tomorrow.
Thank you.
Great.
Thank you.
Cheers, bye.
We're going to take a break.
So, shall we take the break, Ms. Falk, now? And is half an hour long enough for you? Half an hour long enough for you? Given we're all in our homes with our offices?
Yes, that's fine from our end too.
Oh,
Okay.
Ms. Walt's changed.
Commissioners, I might just raise a procedural point before the break, if you don't mind. Ms. Walt made reference to Mr. Buckham speaking. I just want to note that Mr. Buckham hasn't filed any evidence in this matter, so I just want to raise a point there as to what his speaking might involve, and that we have not had any prior warning or notice as to what that might be.
Very good point.
If I can respond to that, Mrs. Buckham is unwell and has a sore throat and is finding it difficult to speak. And so Mr. Buckham was going to present her evidence on her behalf.
So, if I get this right, so Victoria, Ms. Buckham is not well, so Mr. Buckham is going to do what she was going to do. Is that correct?
Correct. Yes.
Right, we'll have a quick think about it over the break. Come back. Right, we'll send it until 1 o'clock. Thank you.
Thank you.
Yep, hit that. It should work. Ready? It. Microphone's working. Hit it, hit it, hit. Yep. Bingo. You're on. We are fine. Hello, 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 hello. We're good. Yep. Should be good.
Yeah, no, we're all good. Yeah, I can hear all that. It's fine.
Maybe it just said.
One. I just had the half hour.
Great.
What?
All right. Welcome back, everyone. It's just ticked over 1 o'clock, and if we could just all come back, that would be lovely. So just to deal with the issue of Mr. Buckham, we had a quick discussion over the break about that. Given this lay evidence and given that Mrs. Buckham is not well, we don't really have too much of a concern about, and given he's also an owner of the property, we don't have too much concerns with that issue, so we're happy to proceed on that basis. So back to you, Ms. Volt. Are we going to go to Mr. Giddens over the conditions and then go through to noise and heritage and then come back to planning? Is that what you're proposing?
Yes. I think perhaps the order might be Mr. Giddens with conditions, Mr. Buckham subject to the
Right.
commission views on that, Mr. Miller heritage, and then Mr. Hay noise, and then Mr. Giddens wrap up.
Okay, thank you very much. So we go over to, so Mr. Giddens is going to walk us through the conditions and then maybe answer some questions about the actual, picking up the discussion we've had about the actual activity and such like, and then we're going to go back to him later to deal with planning matters after that. Okay, that sounds all good for us.
Yes.
All right, over to you, Mr. Giddens.
Yeah. Good afternoon.
Good afternoon. So we've got the circulated conditions that were given us today. Are you going to? So that's what you're proposing to walk us through?
Yes, that's correct. I was just going to double check with you. It's the conditions that were sent through, I believe, from Trish this morning.
Yes, we have those. All good.
Yep. Perfect. I'll walk you through some, and just by way of background, we provided draft conditions to Ms. McConnell prior to preparing her Footage Way report, which she quite helpfully updated. That's part of that bundle. That was the main document that I was referring to in my evidence, and where I didn't refer to specific conditions, but I made suggestions. It was on the intent of waiting to see if there are any further issues that came out from the submitters, so I'm not bombarding the commission with versions and versions of consent conditions, which just creates more issues in itself. So just from a point of background there.
That's all good, thank you.
If I can turn you to condition 3, you'll see that this reads, the regular day-to-day use of the property shall be for rural residential activities. And when I was formulating this updated set of conditions, I actually reverted back to some of the most recent consents that have been authorised by the council. And just for the commissioner's benefit, that came from RM201050 was the consent reference. And I thought it was quite helpful because it actually is quite relevant for the Buckhams in terms of underpinning what the use of their property is. It's the only time I've seen that condition being used, but I thought it was quite relevant in this regard. So it's really to help underpin the intent of the consent as that condition.
You've got a copy of that consent, Mr. Giddens?
Yes, I can send that through to you, Commissioner.
Thank you.
Condition 4, this is under the operational conditions. This is essentially the condition that guides the number of events. And as in terms of amendments for what's been changed from the set included within the section 42A report, the most notable there is the cap of a maximum of 24 temporary events undertaken within outdoor area 1. That's the area next to 67 Speargrass Flat Road. That cap was what I suggested in response to the evidence of both Ms. Tate and also Dr. Verthen, not only relating to duration and intensity of events, really trying to capture the essence of what the Buckhams want to do. They don't want to do 100 events in outdoor area 1. That was never the intent, and I can appreciate if someone's taken an extreme maximum view of the proposal, that could be a worst case scenario, but I think when you read the breakdown, that wouldn't occur. So that's where the 24 came from. And that actually links into the proposed condition 5, which provides further, it's more of the respite issue that Dr. Verthen mentioned, that no more than 2 daytime temporary events shall occur in outdoor area 1 in any given week. So it puts a weekly cap. and in addition that no more than 2 such events shall occur on consecutive days. So it's really addressing Ms. Tate's assumption that events will be occurring in this area day after day, after week, until the 100 events are used up. Just back on condition 4.
No more than 2 such events shall occur on consecutive days. Is that to stop 2 weeks backing to back? Is that what that means?
Yeah, it's to prevent backing up of events essentially. So so the first part of it is no more than 2 daytime temporary events shall occur in any given week. It would be, for argument's sake, if there was Saturday, Sunday, Monday, Tuesday.
We need to define what a given week is. Yes. So if you simply said in any 7-day period, you would also have covered that.
That's a good suggestion. And just going back to 4B and C, these were part of the original conditions, so the maximum of 12 temporary events that can continue after 8 p.m, but cease by 11, and then the temporary event duration of 6 hours, which was also contained within the Section 42A set of conditions. And just quickly on the terminology that I've used for temporary events throughout, I've used that because it links to the definition that's contained in the PDP. If you compare this suite of consent conditions to other consents, quite often they just use the term events or commercial activity or commercial events, and that really depends on where that decision lands in terms of, is it a commercial activity or is it a temporary event? So I just want to flag that if the Commission was minded to grant consent, that terminology could be changed to suit. Condition 6 specifies no more than 4 temporary events that extend past 8 p.m. shall occur within a calendar month. And in addition, no more than 2 such events shall occur on consecutive days. That's similar to the condition 5, to prevent the stacking of activities, to provide respite, and just to reduce the overall scale, given that there's only 12 events proposed over an annual period. It would mean that those events would be used up relatively quickly if someone attempted to stack it. So it's quite a foolproof way of, I think, to address that issue. Condition 7, this is the condition that generally relates to the numbers of guests, and also deals with when events end, i.e. the 12 temporary events, they cease by 11 with guests off site by 11:30, and all other events cease by 8 p.m. and with guests off site by 8:30. So that's a critical timing condition. Condition 8, no more than 1 temporary event shall occur on a property at any one time. And when I use the term property, it's not a defined term under the PDP. That the PDP defines site. Property is how I've described 31 Speargrass Flat Road. So the 2 sites together, which I think makes it a lot easier for consent administration purposes.
Sorry, can I just take you back to the number of staff or number of people, which excludes staff?
Yes.
I accept that Ms Buckham is intending for these to be low-key events, and that Mr Bartlett has made an estimate of how many staff vehicles might be associated with an event. I'm also aware that this district has some quite extreme staffing requirements sometimes. Is there any benefit in restricting the number of staff?
I think in the current climate, I think you'll be lucky to get staff.
I get that too.
No, I do think I had put some thought to that, and one of the things that I did traverse quite a lot of detail was going back through some similar consents for commercial activity convents and facilities, and trying to see how they handled the staff matter. And it's actually not something that's commonly addressed, and I couldn't find any examples of where people have kept it. And I guess my fear would be if we said, for argument's sake, in that condition that no more than 10 staff can be engaged in the activity at any one time. My fear is there that for an event, you might have 2 or 3 staff coming to set up and do some initial work, 20 minutes, 30 minutes work, and then come back a little bit later. Where does that 10-person limit start and finish? I think it would put the Buckhams into a bit of compliance danger in terms of how they would ensure that would occur. And then if the number wasn't sufficient, then it puts the event management.
I don't suppose I was thinking of a very low number. I'm more thinking of a case was put to me recently that somebody needed to have their driver and their bodyguards come with them, and all the people needed to have their driver and their bodyguard come with them. So that was 3 staff for each guest. And that's before you've had any caterers on site or any event managers. And that obviously, when it was extreme, and I get that I am now in the extreme, but I would have thought that 150 guests and 150 staff should be ample. That kind of limit I'm thinking of, that we should actually just put that in place and say, look, guys, yeah, absolutely staff, but within reason.
I'm happy with that, Commissioner. I think the instance of having one guest with one bodyguard scenario would be, a little extreme. However, it is one of those things where, I'm just thinking out loud, where it refers to staff in the condition, maybe it just needs to be specific to excluding staff engaged in the operation of the event. I wonder if that addresses your issue.
I think that thought with you. It's just something that has come up recently, and so it's at the forefront of my mind that probably do need to be a little bit more specific in that area.
Yes, thank you.
Shall we move on? Thank you.
Yes. Condition 9, no temporary event shall occur simultaneously with a temporary filming event on the property, and that's in response to, I believe it was Ms. Tate's comments regarding cumulative effects and temporary filming occurring at the same time as a temporary event. That condition was actually as part of the Section 42A report suite as well. There's no intent for that. Condition 10, this was set out in the previous version as well. I won't traverse this, but it relates to the more specific controls on the activity areas within the property. And I call them activity areas because they've got different facets of a control and different amenities that they provide. Probably most notable is that the stables has a guest limit of up to 75 guests. And also outdoor area 1 has been reduced from 150 guests down to 75 guests to assist with that management and deal with the issue of proximity to the adjoining neighbour. One thing that Mr. Hayes quite helpfully worked through with me is the last table on that condition. And it came through with some discussions that I had with him about whether we can identify a specified noise limit for controlling outdoor noise. And in my experience with dealing with events and being on the other side of events for enforcement purposes, it's quite nice and quite practical to have a qualitative descriptor as well, so that someone can go out there and hear the noise and say, this is clearly triggering off a wee radar on my head that this noise is a bit loud. So that right-hand side column is really what that seeks to achieve, whereas the middle column with the dB readings is your more quantitative descriptors there. Condition 11, this is where the consent holder is required to keep a log of all temporary events on the property. And I've specified there the date of the event, location, type, numbers that attended the event, start time and end time, and details of any noise complaints, and importantly, how they are addressed. And for that log, if the council requests it, be made available for them. My thinking behind that was it was useful for compliance purposes in particular. If there was an allegation of an activity being undertaken that was outside consent perimeters for argument's sake, or if the council wanted to verify what had gone on, there's an onus there on the consent holder to have that log and make that available to the council. Condition 12 is based off, there's a number of consents that I reviewed that had the requirement for noise and operational management conditions. I've actually quite substantially reworked this condition to tailor it to the Buckham's property. It did take a little bit of work, to be honest. I was trying to set out what the objectives of a noise and operational management plan would be on the property, and make it clear that that's the document that the Buckhams must abide by as consent holders if consent's granted, and also for event managers. There's a noise and operational management plan included with the application, so this is essentially requiring a new one, essentially to be provided. and is, if you see my list of A to N, that essentially lists the detail that needs to be included in the noise and operational management plan. And for lack of a better word, you can call this the Bible. At the end of the day, it will be kept on the property. It'll be the document that's that if anyone's got any queries as to what you do, this in conjunction with the resource consent should really provide that document and that insight.
Mr. Giddens, you've called this a noise and operational management plan, but it appears to just be a noise plan.
Yeah, it started life as a noise management plan, Commissioner, and I changed it to an operational management plan because to manage noise, you're doing that as part of the operation. I've used that term a few times in other consents in the past for events, and especially for large scale events, upwards of 15 to 25,000 persons. And I think it's just clearer to a lay person that it's not just about noise; it's about managing nuisance effects and things as well. So that was the rationale behind it.
So your objective should be updated to include nuisance effects.
Yes, I agree.
And I guess the other thing which I'm missing here is if it's an operational management plan, matters like the parking issues.
Yes.
You've got guests not lingering, but not no parking on Speargrass, which I accept comes in further on.
Yeah, I made a comment actually next to that when you were speaking with Mr. Bartlett before. My comment there was parking and access to be provided in here. Reflecting back on that condition that Mr. Bartlett was discussing, I think it would be quite helpful to include that within this document because it's really there to set the perimeters as to what we'll do. The only bit I'm probably just a little cautious on is being too specific on parking areas because, as you've heard from Mr. Bartlett, we do need flexibility in terms of the consent framework for the Buckhams in instances such as wet weather, boggy sites, anything like that. So as long as I guess we can accommodate some flexibility within the noise management plan around that, I wouldn't have any issues with including that within that one document. Commissioners, would you like me to run through A to N or just move on to 13?
Yeah, move on to 13, please.
Okay. 13 is a copy of the noise and operational management plan to be kept on site at all times, and the activity undertaken in accordance with it. So that's a clear compliance condition. 14 provides for changes to the noise and operational management plan, and this is quite common when you see even noise management plans where circumstances change, or if there's been an issue that's arisen, i.e. some of the equipment may need to be recalibrated, or a verified complaint's arisen that warrants changes. That's the condition essentially enabling that to happen, but obviously with the approval of the council in doing so.
Yes, and you don't seem to have provided for the approval of council in your condition.
Oh, sorry, provided the council within 10 working days of the changes being made.
Yes, I think it needs to be certified by the council. I don't think making changes makes it a new plan, because originally it had to be certified. I think the changed plan needs to be certified as well.
It's agreed. Uh, 15, the consent holder shall provide a copy of the noise and operational management plans to hires and managers of temporary events to ensure they're familiar with it. This condition in the second limb puts the onus back on the consent holder or the representative to be on the property at all time where temporary events to ensure compliance with the noise and operational management plan. I did originally have the consent holder shall be on the property at all times, but I don't believe it's unreasonable to delegate that responsibility, providing the person they delegate it to is familiar with the noise and operational management plan, familiar with activities on the property, and cognizant of those issues. So that does provide some degree of flexibility, but at the end of the day, these consents will fall back on to the consent holder in terms of compliance.
So does that representative need to be listed in the noise and operational management plan, or a list of representatives?
Yeah, I think that could be one option. I know from my discussions with the Buckhams that they only use a select number of event companies, but I guess that could change if they did specify event managers within that noise and operational management plan. I guess we do have the ability there for that plan to be updated. So that could be an option.
Or to have a representative on site with that event manager, which is what I was actually imagining.
Mm.
Or imagining the event manager would be the representative.
Yes. Condition 16, this is the complaints procedure that needs to be maintained by the consent holder. So this is essentially your point of contact. If there's a problem, you need to contact the consent holder, which is the Buckhams. This condition actually came from Ms. McConnell, which basically means if the consent is granted, all these persons need to be provided a copy with the contact details. I will note there that there has been 4 properties removed from this list, being the ones that have the covenants on their titles. Condition 17, this is relates to within the farm building, and this sets out essentially the required calibration. And just to give that some context, the farm building is I guess the only part of the site where activities could occur which would be loud enough to have music and dancing. So in effect, this condition is putting controls on that in terms of noise output, which is obviously being assisted by Mr. Hay in terms of formulating this. Condition 18, this just reiterates the outdoor areas. So the only outdoor areas that can be used after 8 p.m. are those breakout areas for the stables and the farm building, and they're identified on the site plan. Condition 19 is new. This is more in response to Dr. de Verthen's comments about his preference to see specified noise limits within the consent conditions. And on that issue, when I did traverse quite a few of the consents, some had consent conditions with measurable numbers, some didn't. It seems to be an approach that is taken in some circumstances and not in others, but I'm happy to suggest it for this consent. I think it helps provide some uncertainty and increased enforceability as well. Condition 20, this comes off condition 19, where it relates to the operational noise monitoring to determine compliance. And this again is in response to Dr. de Verthen in terms of having some degree of validation of what the noise will actually be.
My brain's still on condition 19. The noise condition that you've proposed, or the noise limit from 10 a.m. to 8 p.m. is at the notional boundary, but the requirement within the lifestyle precinct is at the boundary. And my understanding is it meets at the boundary. And my understanding is there's no breach of daytime noise limits.
Yes, that's correct. I might defer that the discussions on that condition to Mr. Hay, if that's the right, Commissioner. I don't want to set you wrong on a point.
I will keep that one for Mr. Hay.
So just back on condition 20, so that's the operational noise monitoring condition. And with that, there's timeframes as to when it needs to be done within a month of operation of the consent. And it specifically pinpoints a temporary event taking place during the daytime in outdoor area 1, which is the property, the part of the property next to 67 Speargrass, and after 8 p.m. at both the farm building and the stables. So the intent of that is to make sure that the operational monitoring is getting a good spectrum of the upper level effects there. And then I'll draw your attention to C, because I thought that would be quite useful to include in there, where it provides if compliance isn't achieved, then there needs to be changes made to the activity to make sure it does achieve compliance. And that's what C sets out. And those types of things could be reducing activities, reducing the form of music, making changes to where activities are held, for argument's sake. I think it's a very good belts and braces outcome. I think that would arise from monitoring.
So that monitoring at condition A of the event, would that be a 75-person event?
It would be a 75-person event in outdoor area 1, because that's the cap. And then the farm building and stables both allow up to, the stables has 75 person capacity as well. The farm building would be up to 150. So I guess the way the conditions worded at the moment is to be no certainty that that would be a maximum patron monitoring.
So it would be monitored with the maximum number of people there. That's my point, I suppose.
In discussion with Mr. Hay, he mentioned to me that there wasn't too much different from a noise perspective between 120 and 150 persons, and he'll be able to clarify or qualify that a lot better than I can. But I wonder if we put a bit of a range in the farm building rather than saying it has to be 150, because 150 was always set as a maximum limit, and it may well be that there won't be 150 persons that have been engaged in an event. I think if we had between 120 and 150, would at least give the consent holder some ability to look at a near worst case scenario.
Okay.
So turning to condition 21, this is essentially a condition, again, that was promoted by the council that requires that no less than essentially 2 days before the event, there should be a notification done to the surrounding neighbours of the events. I amended that condition so it related only to those events that extend past 8 p.m. And the reason for that, I know from the discussions with the Buckhams and from what I've done for my own research that many of these events are just going to be very innocuous. So I think in terms of advising neighbours, it would be those sensitive events that occur after 8 p.m. that I would consider would be of issue. So that's hence amended that condition. Conditions 22 and 23 relate to lighting. There's no changes there from what was in the section 42A report, and much the same from conditions 24 to 26 relating to sanitation and waste. What I have changed, however, is condition 27, and this relates to marquees and portaloos used for temporary events. Firstly, it requires marquees to be located in the ruins and outdoor area 2. So that means that marquees will not be located within outdoor area 1 next to 67 Speargrass. Also requiring that portaloos be located in the general locations shown in the site plan, which those locations were what I discussed with the Buckhams, generally aligned with what where they've been placing such infrastructure anyway. But from when I viewed from the road, they had minimal direct views. So I think they'd be relatively discreet in that instance as well. And then the last point there, C, is that marquees and portaloos should be established no sooner than 1 day before the event and removed no later than 1 day following the event. I had a little bit of trouble with this condition at the start, thinking, is it too onerous given what the plan expects with marquees? But I guess where I arrived at is that if there was a bond put in place, for argument's sake, on those event hirers, then it actually provides the Buckhams a recourse to have that equipment moved in accordance with that consent. So I think that's kind of the stick approach. Traffic management from 28 to 36. Just wondering if you'd like me to discuss anything further on that from your discussions with Mr. Bartlett earlier.
I think we can move on to 37, please.
So 37's the heritage conditions, and 37 was taken from the heritage advice provided to the applicant, which was set out in the section 42A report as well. In terms of changes, the only change there is condition 40, which there should be no erection of temporary structures and marquees within 1 metre of the ruins, and I believe that was drawn from the heritage assessment that was appended to Ms. Tate's evidence. I've kept condition 39 in there. That was a condition proposed by the council. I was a little confused as to what its intent was, because that area where it refers to planting from Speargrass Flat Road, essentially to where the edge of the stables building is, it's actually already planted. So I just wasn't sure. I was going to have a discussion with Ms. McConnell, sorry, to ascertain what the intent of that condition was, and particularly given there's going to be a wall in that location. It may well have been that she was thinking that the wall may start further back, which again, Mr. Hay may be able to respond to that from a noise perspective as to whether it's needed. But that's, I just want to flag that condition as I'm just not 100% sure on its reason.
So it says planting along the roadside boundary. There's not going to be a fence there, is there?
Yeah, it's a little bit confusing. I've been reading that it's planted along the roadside boundary of the eastern vehicle access to the site in 67. I was reading that to be along the boundary of 67 back to the stables. So I guess if you're talking about it from the eastern access through to 67, I'm pretty sure there's planting along there as well.
Okay.
I'd have to double check it, but yeah, I'm positive there are areas that are quite well planted.
From our site visit yesterday, that boundary didn't seem particularly well planted. Obviously, this is not the time of year to see planting particularly well, but it seemed very open. I couldn't say about that exact location though.
Well, I was just going to have a look at the photos actually, just to clarify that while you're going through it. But I seem to don't remember that as well. Yeah, I'm looking at the aerial photograph. Maybe they've been trimmed since the aerial photograph, and it shows a large line of trees along that boundary. And maybe Ms. McConnell can explain what the rationale behind it may well be to prevent lower views potentially into the site. But again, I think that would probably just distract from the heritage building itself. But yeah, I don't really have a view either way on that condition.
We might come back to that point then at some point.
Thank you. Keep going.
Signage condition at 41. So that's requiring that any temporary signs or markings be removed no later than the day following the temporary event. That's again to respond to Ms. Tate's concerns about equipment and signage and everything being left on site for undue periods of time. And as Ms. Walt briefly touched on earlier on, the review condition I've added as well. And notably at 43, I've made a specific reference there that as part of the review, the council may have the noise and operational management plan audited at the consent holder's expense. That's quite a common requirement on noise generating activities and consents.
Thank you, Mr. Giddens.
Thank you. Any other questions? Thank you very much.
Thank you.
So is it Mr. Hay now?
Not Mr. Hay, Mr. Buckham, unless
sorry for Jim Pickers, we had a chat over the break about that. Given this is lay evidence, it's not professional evidence, and given he owns the property with his wife, and his wife is sick, we don't really have a problem him doing this for us. So it's all good to proceed.
Thank you. That seems appropriate to me as well. So Mr. Buckham will just read a review, a summary of the evidence that's been filed. And that summary was provided to you this morning, so hopefully you have it to hand.
Yes, we've got that. There you are.
Good afternoon, Commissioners.
Good afternoon.
Thank you for allowing me to speak. In fact, my wife and myself are a bit indisposed today, which is a very timing often is, isn't it? But my wife is here, by the way, anyway, in case you have any particular questions, etc. you'd like to pursue.
Yes, so we can take a lot of this. You can just skip through this because we will be rereading it if you want to. I don't want to put you out if you're not feeling the best, like with your wife and such like. So happy for you to read this, but I'm happy for you just to skim through to the key points that you want to bring to our attention to save if you're not feeling the best.
I'm conscious of time, of course, but I will read most of it if I may, and I'll move forward. But thank you for hearing me. So 1 to 3, I think is self-explanatory. Under 4, and please correct me if you can't hear me because I appreciate I'm a bit croaky today.
All good. Please proceed.
Okay. Family members of 5th Generation Queenstown are known the Buckham Brewery site, Earl Street, Queenstown, for many years. With the destruction of the Buckham buildings in 1974, our family's interest in historical premises and the history of the Wakatipu area developed into a concern for the preservation and enhancement of those historic sites still remaining. Vicky and I purchased Selby Domain in 1991. When we purchased the property, the historic buildings were in a state of disrepair. Since then, we've invested considerable time and resource into the buildings, restoration and upkeep, and in the maintenance of associated grounds. Annual maintenance and related costs of the heritage aspects of the property are significant, averaging around 40,000, 50,000 per annum. We fund these ourselves. Now, the relevant point there, of course, is that it's a variable every year. It depends on how much work we put into the buildings themselves as compared with tree maintenance, tree surgery, gardens, and other incidental costs that all pertain to that. So it fluctuates and will fluctuate in the future depending on what we do and what work we can undertake. And so it's self-explanatory, I believe. Under 7, it's important to us to keep the property well maintained, as this contributes to a special character and the appreciation of its heritage values. This includes the grounds. Mowing the grassed area around the buildings can alone take up to 10 hours. We still mow them, all the grass, as you may have noticed, having tried any number of other ways to control it, but mowing is the most presentable and effective, but time consuming. 9, we continue to work towards restoring the buildings to ensure they last beyond our custodianship for future generations. 10, the buildings and their immediate surrounds have a Category 1 HNZPT listing and the Category 1 listing in the Queenstown Lakes District Council. The HNZPT listing was afforded in 2014 with our encouragement and after we had undertaken significant restoration works of the buildings and maintenance of the grounds. The property, especially around the historic buildings, is extensively planted and includes a number of protected trees, as well as numerous orchard trees, many of which were planted around the time the buildings were established. The property provides a significant crops, which we harvest and share. There's a lot of fruit trees here, as you may have noticed, nut trees and the like. The entire property is not only used for this, but provides our recreation area and further provides for our daily walks. The historic buildings provide for storage of our personal effects, including sporting equipment, a collection of historical relics, as well as for storage for equipment and tools for maintaining the property, and for vehicle garaging and firewood. We ourselves reside in the property in a dwelling that overlooks the buildings and grounds. The property garners much interest from passers-by, as does this part of Speargrass Flat Road more generally. Many people wander onto the property to view the buildings and at times for picnics and photography, perhaps on the assumption that the property is a public reserve. While we do not directly encourage this use, we take no issue with it and are generally happy for people to enjoy the property provided they respect it. We've received requests to use our property for temporary events since acquiring it in the early 1990s. We have at times agreed to this use. We have at times agreed to this use while always cognizant of and observing parameters set out in the district plan in which we have taken advice. The property has been used for many community events such as school parties, coming for historical visits, particularly through history advocate and teacher, the late Ray Clarkson's school and parish picnics, private family picnics, children's plays, for example, one being the Selfish Giant, local clubs, daytime gatherings, plunket afternoon teas, foreign garden tours, historical society activities, cycle and walking groups, photographers, photographic groups, artists, art groups, classic and vintage car gatherings, fruit and nut harvesters, tree and landscaping enthusiasts, and members of historical families who have had association with the Hellenstein and Allen families in particular. All these groups come out on a goodwill basis. The property has also hosted weddings and wedding photography, although we have not ourselves marketed it for that purpose. That has been done by other people. Through this proposal, we wish to provide for a greater level of use with the intent that the income received from private use may offset some of the ongoing costs and restoration costs. It will, however, by no means cover these costs or the costs of this consenting process. In seeking this consent, we are not motivated by commercial gain. Instead, we wish to be able to share our property more widely while continuing in our role as custodians and actively preserving buildings through maintenance and works and restoration. We are aware that with a greater level of use, we will need to take a more active role in the management and oversight of events, we're happy to do so. We understand that Mr. Giddens' proposal consents, conditions, and provide for this. Submitter evidence. We're aware that expert evidence has been filed on behalf of a group of opposing submitters. This raises a number of matters that our own expert will respond to. There are some matters on which I wish to make comment also. And I guess my brief comment there would be that perhaps naively, we've both been disappointed in the sort of personal aspects of this particular process and the lack in a lot of cases, in our view anyway, of objectivity. And unfortunately, it's affected the neighbourly relationships, particularly with the neighbour in 67. If considered relevant at all in terms of the relationship, etc., then I'm happy to talk about it. But it's just an expression, I think, of my observation of the process and the disappointment as to the manner in which it's been dealt with. And so perhaps that's a naivety on my part. Number 20, a neighbour at 67 Speargrass Road is apparently particularly opposed to our proposal. She raises various issues and allegations that are without substance, as Ms. Walt has addressed. She takes issue with the replacement of the boundary fence. The planning evidence of Ms. Tate filed on behalf of this neighbour also takes issue with the fence, suggesting that it will adversely affect their neighbour's amenity and landscape character. From our perspective, the primary reason for proposing the fence in this location is to address privacy. I understand that it also serves an important acoustic purpose, but that is not why we proposed to construct it initially. Rather, our reason for proposing the fence was to respond to complaints made to us by a neighbour of seeing people on our property in the courtyard area adjacent to the stables of Cowboy outdoor area 31. Indeed, myself, I met with this neighbour at a common offence on the 27th of February this year, actually had an extensive discussion. The only concern she expressed to me at that meeting was of people in outdoor area 1, as now defined, looking into her property. She likewise been able to see these people. That was the last meeting that we had with this neighbour, and otherwise no other concerns were expressed at that time. As I have explained in my evidence, these complaints are surprising given this neighbour has previously marketed their property as accommodation for bridal parties and the like in association with temporary events on our property. Nonetheless, we have previously undertaken some boundary planning to address this neighbour's concerns, but in their submissions, they have taken issue with that also. It would seem that this neighbour wishes to be able to look into our property and view the buildings, but not have us use them or adjacent courtyard areas or for other people to enjoy the properties likewise. The fence is proposed to address this neighbour's concerns about privacy, but also our own. During the course of this process, we've observed when taking the property with our planner, Mr. Giddens, and lawyer, Ms. Waltz, a camera mounted high on a tree in this neighbour's.
Troubles, Grace.
Sorry?
Oh.
Sorry, Trish, you just on mute.
I was 25. Is that the question?
No, please proceed, sir. Just Ms. Anderson wasn't on mute.
My apologies. I'll repeat 25. The fence is, as proposed, is to address this neighbour's concerns about privacy, but also ours during the course of this process. During the course of this process, we have observed when taking in the property with our planner, Mr. Giddens, and lawyer, Ms. Walt, a camera mounted high on a tree in this neighbour's property, looking directly into our courtyard area, outdoor area 1 on the property. We're unsure of the purpose or legality of this, but its covert nature is of considerable concern to us. That was actually on that lovely pink blossom cherry tree that you may have observed yesterday. In response to this neighbour's allegations that we have disregarded any concerns she has expressed to us about the use of our property in the past, this is incorrect. As above, we have undertaken boundary planting in an attempt to address complaints made to us about seeing people on our property. We also approached this neighbour directly earlier this year and many times prior, following complaints made to the council about the use of our property for temporary events, which complaints were found to be unsubstantiated. This neighbour denied having made any complaints, although it can be readily ascertained from information since provided in response to our LOGOIMA request about the same, which we made with a view to understanding the nature of the complaints in order to take steps to address them, that they were indeed made by this neighbour. 27. I'm aware that Ms. Tate suggests in her evidence that the use of our property for temporary events will occur in the summer months, and that all events will be stacked into this period. This is incorrect. We receive requests to use our property year-round. Some wedding parties are attracted to the more stark and dramatic appearance of the buildings in the winter when trees are not in leaf. The autumn colours of the property are spectacular, and this is desirable for groups. Springtime is also beautiful with abundant new growth. Recreational and community groups use the property year-round also. Thus, demand for use for temporary events is spread throughout the year. 28. In response to another of Ms. Tate's points about using the property as one site, which I understand is relevant to how the district plan is interpreted and applied to our proposal, the locations for events on the property are for the most part used individually of each other. Wedding ceremonies, community and group picnics and the like mostly occur near the ruins. Sit-down dinners may occur in the stables or farm building. Only very seldomly is more than one area on the property used for an individual event, for example, a wedding and a wedding reception. Although we have not hosted many of these in the past due to restrictions on opening hours under the district plan permitted activity rules. And our proposal only provides for 12 such uses annually, where wedding ceremonies could be followed by a reception that carries through into the evening. This tape refers to large hyped up intoxicated groups at events and catering marquees, large service vehicles and the like being required for every temporary event on our property, pursuant to our proposal. These assumptions are incorrect. The nature of the property and the types of uses it attracts and suits do not involve large hyped up groups. We simply don't have the facilities for such groups, nor do we wish to accommodate them. Note again that we also reside on the property and maintenance of our amenity is as important to us as it is to our neighbours. The nature of the uses I have listed in my evidence demonstrate that there are a mix of groups that wish to use our property, most of which are self-contained, with no catering or services required, involving events of relatively short duration. Even a wedding ceremony generally lasts no more than 2 hours. 31. There is simply no intention to host 100 events on our property or with 150 guests and full catering and services. It's been difficult to articulate a proposal and the corresponding consent conditions due to the nature and complexity of our property, with its multiple areas suitable for temporary events and the multiple and different types of community and private groups that wish to use it for such events. Although we understand that our expert advisors can support it in its current form, we're open to making further refinements to the proposal that the panel may consider necessary. So thank you for bearing with me on that.
Thank you very much, sir. Would you open to taking some questions from us?
Certainly, yes, indeed.
Is there anything?
Thank you, Mr. Buckham. I only really wanted to comment on your paragraph 31, which is there is simply no intention to host 100 events at our properties or with 150 guests and full catering and services. And I take your point that that may not be your intention, but that is what your consent is for. And anybody, even if you yourselves don't do this, if at some point you were to sell, this consent endures in perpetuity. So we have to assess it as if you were.
Yes, no, I certainly understand that. I guess dealing with parameters on any particular activity or consent is always a little difficult. And I guess I'll have to refer or defer to Mr. Giddens' conditions of consent, which were prepared in trying to address indeed all outcomes, positive or negative, and including the fact that this refers to the 150 guests with full catering services referred to. Now, so I appreciate that doesn't necessarily answer your question.
No, it was probably more a comment than a question. Just my only other real question to you is about I suppose the sense of place of the property and how that relates to the property at 67 Speargrass Flats. Obviously, you have a very good sense of the property and of all the activities that have been undertaken there and what all the different structures mean. And obviously, there's this gate entranceway, which is on the property of 67. Is there benefit in those being visually connected, in your view?
No, I don't believe so. The house next door, which was built by an earlier owner, Ron Gordon, was, as you would notice, a 50s house. And at that time, the area is quite barren. And the gate you may have seen on that particular fence line was a remnant, in fact, of his earlier ownership of the property before we actually purchased it. When, from his point of view as a farmer, of course, he did walk between the house and the buildings, but since then that's been effectively locked and hasn't been used for vehicular access or pedestrian. So, and with the vegetation there and the completely different context and concept of the buildings, I don't believe there's any connection between the two.
Thank you.
Thank you. I'm just trying to find the exact way you talked about, but you talked about what the activity is used for at the moment, and it's a range of things. Here we go. Your paragraph 15. I'm just trying to get my head round actually what's happening there now. So, how many at the moment? How many sort of weddings do you have a year, or how many weddings per year do you usually have at the moment?
Well, we're constrained by the district plan rules, which allow 7 per site, and that's what we arrange our fares around. So
basically, you sort of, in essence, for better use of words, hit the limit of the plan, the district plan, and that's why you're seeking to do this consent.
Yeah, well, there's two aspects to it, as I always would see it. One is that we have significant demand for it for the use of the property, but also the sorry, bear with me. Oh dear, what I was going to say to you, my apologies. It was very important also.
It's not good, so take your time. No rush.
That's fine. Sorry, it's old age keeping up on me. One of the issues which has been addressed, which is a plus or a minus depending on how one views it, is the fact that we have a number of people just wander into the property assuming it's a domain. And we haven't discouraged that. In fact, we've encouraged it in a lot of ways. And one of the issues we've addressed with our legal advisors and planners, of course, is, well, what is an event and what is not an event? And so in terms of ones that we control, whether we charge for them or not, we're constrained by the district plan. And this application is, if deemed to be approved, allows us, one, to make the property available to more people who wish to use it, whether it's for a wedding activity or whether it's just a school picnic.
Okay, thank you very much. And just purely for my own interest's sake, is this the property that Magdalene cheese commercial is on? Indeed it is, yes. I just wanted to be sure while I was there. Thank you very much. That's all from me, sir. Thank you very much for your time.
Thank you very much.
Thank you, Commissioners. Now, Mr. Miller will present his evidence summary.
Just bear with us. Thank you. Just okay. Yes, got that. And as I don't know if my colleagues run into you, Mr. Miller. I've never ran into you before, so no disrespect for you. Unlike Mr. Buckham, who we have seen many times. Do you mind if you do start paragraph 1 for us?
Yes, definitely. Good afternoon, Commissioners.
Good afternoon.
So my full name is Robin Alexander Keith Miller. I'm Director of Origin Consultants in Arrowtown and Dunedin-based practice specialising in heritage architecture, heritage conservation, building surveying and archaeology. I've over 30 years experience as a chartered surveyor, and for the last 18 years have specialised in heritage conservation, and the last 12 of those have been in New Zealand since I came to Queenstown. I've been engaged by the applicant, Victoria Buckham, to provide advice and give evidence in relation to the proposal for temporary events at Thirlby Domain. I have prepared a heritage evidence dated the 2nd of September 22 in respect to the proposal. I have the qualifications set out in paragraphs 3 to 4 of that evidence. We've also prepared a heritage assessment dated the 30th of June 22 that was filed as part of the applicant's response to the council's request for further information about the proposal. I visited the property on several occasions. I'm therefore familiar with the property and the proposal to utilise it for temporary events. In this statement in the summary statement, I will provide a summary of my earlier 2nd of September evidence and address matters that have risen since I prepared that evidence, including matters raised in submitter evidence. So on to my summary. In my heritage evidence dated the 2nd of September 22, I reaffirmed the conclusions of my heritage assessment dated 30th of June 22. I also outlined areas of maintenance needed on the property, provided a comparison of the proposal with similar heritage properties, addressed submissions raising heritage matters, and responded to Mr. Knott's peer review. In summary, Thirlby Domain has high heritage significance associated with its establishment by Bendix Hellenstein, who played a significant role in the early development of the Wakatipu Basin and wider region, and as a remnant of the early agricultural hamlet around Lake Hayes. The buildings have high architectural value as structures designed by the architect F.W. Burwell and are representative of the local vernacular. The historical record also indicates that Thirlby Domain was a site known for hosting social events and community gatherings. The proposal relates to the proposed use of the grounds and buildings of 31 Speargrass Flat Road, known as Thirlby Domain, for temporary events, including weddings, social gatherings, picnics, and photography. Temporary events will occur throughout the property and within the buildings. I was requested to consider the impact of the construction of an acoustic fence along the boundary with 67 Speargrass Flat Road and car parking in informal areas on the heritage values of the site. No other physical alterations to the buildings or grounds have been proposed. The extent of place of Thirlby Domain listing is defined in the district plan as encompassing 2 areas linked by a corridor of land along part of the driveway and the road fence line. The wooden cottage, corrugated farm shed, stone cottage, and 2 stone stables, one's called a cow byre, buildings are included in one area and the ruins in another, linked by a 500mm strip of land that runs along Speargrass Flat Road and a section of the driveway. The listing also includes the iron gates and an area of 1 metre around the ruins. Heritage best practice outlines that conservation of heritage sites is facilitated by the site serving a useful purpose, and ongoing maintenance is also required to ensure the continuation of its significance and survival of the buildings. Historically, major repairs and restoration and maintenance have occurred to the buildings, but the buildings' maintenance needs are high due to their age and construction, and from time to time they require more substantive works and repairs, as can be expected for many heritage buildings. More substantial maintenance will be required within the next 5 years, with repairs, repainting and repointing required for some of the buildings during this time, together with some structural repairs, as I have outlined in my evidence. Cyclical maintenance will also continue to be required on a periodic basis. The use of heritage sites for events, functions, and attractions is common throughout New Zealand. Heritage sites of comparable significance include sites more commonly owned and managed by Heritage New Zealand, where funds are raised by annual membership schemes or admission. Heritage New Zealand managed buildings are often in the nature of a museum, where an admissions fee is paid to enter and view the building, which is put towards its upkeep. Local non-Heritage New Zealand or private examples of comparable significant buildings include Paradise Homestead at Glenorchy, which is used for accommodation, functions and events, and the Kororo Station Woolshed at Peregrine Winery in the Gippsland Valley, which can be used for functions and events. These sites are hired out as a blank canvas and require services and facilities to be transported to the site. In assessing the impact of the proposal on the site, I relied on the application of Rule 26.5.9, which applies to development within the extent of place. This rule applies to development defined as new buildings, structures, or car parking areas over a specified size, and does not apply to the use of a building or land. I concluded that the construction of a proposed fence may have an impact on the townscape and contextual values of the site, but this would be adequately mitigated by the proposed location, design, and the use of suitable materials. I also outlined that the proposed use of the site for temporary events provides a connection to and continuation of past uses. It will also have a positive impact on the historical and social value of the site by enabling the public to have greater legitimate access to the buildings, which will widen their public appreciation of the place they hold in the development of Queenstown and the Wakatipu Basin. The proposal does not require any adaptations or modifications to the buildings or site to enable its use as a venue, allowing the site to be presented in its original form, which is a further benefit. I also responded to heritage matters raised in submissions, specifically the issues raised by SCTL submission number 27. This submission suggested that the dwelling at 67 Speargrass Flat Road has a visual and historical connection with Thirlby and Thirlby Domain. Seemed to consider that this dwelling formed part of the district plan listing, which is number 31 in the district plan, and that the fence would sever the setting of the buildings. This dwelling has a mid-20th century association with Thirlby Domain buildings and is in close proximity to the site. However, I regard the significance of Thirlby Domain as associated with its establishment by Hallenstein and the cohesive form, materials, texture, and colour of the buildings rather than the later association of the site with Ron Gordon, the owner at the time of 67 Speargrass Flat. As outlined at paragraph 10, the extent of place of Thirlby Domain listing is narrowly defined. The dwelling at 67 Speargrass Flat does not form part of the district plan listing. I considered that the proposed boundary or acoustic fence would maintain the connection between the buildings that are comprised in the listed heritage feature, and view shafts of the fence from within the property would to a large extent be obscured by other buildings. Due to existing vegetation, views of the fence would also be largely obscured. In responding to concerns raised in other submissions, I recognise that the experience of a heritage site may change with levels of intensity of human activity at the site, but I disagree that temporary increases in activity on the site would have a permanent adverse effects on the identified heritage values of the buildings, and note again that it will result in a number of heritage benefits. I also responded to Mr. Nott's peer review contained in the Council's Section 42A report. I know that Mr. Nott and I are in agreement. Thirlby Domain has significant heritage values. The property requires significant investment into ongoing maintenance and repairs to ensure the long-term survival of the buildings. The proposal enables the property to be put to a useful purpose and to generate income, and it is unrealistic to rely on a private owner who can gain no benefit from the property to continue to fund ongoing repairs and maintenance of heritage buildings. I consider that Mr. Nott and I also broadly agree that the fence in the proposed location and of suitable design and materials would mitigate the impact on the townscape and contextual values. Mr. Nott also proposed additional landscaping requirements to further reduce the visibility of the fence from Speargrass Flat Road, which I have no issues with. Our opinions diverge on the required design and materials. Mr. Nott proposed a stacked schist construction with vertical coping stones, whereas I consider that either a stacked schist or schist and weathered timber could be appropriate, with the change in construction method and materials assisting in reducing the bulk of the fence. In considering the impact of the car parking on the site, I deferred to Mr. Bartlett's expertise and assessment that approximately 60 vehicles may be required for larger events. I noted that no permanent structures or adaptations are proposed to the site to accommodate car parking, and I acknowledged that cars parked in the area may have a short-term impact on the perception of the extent of place. However, in my opinion, any impact on this perception would be temporary and limited to the duration of the event. Regarding the cumulative effects of the use of the site identified by Mr. Knott, I considered that these concerns are not within the ambit of Rule 26.5.9, and notwithstanding this, any effect would also be temporary and limited to the time these supplies are transported to the site. And to the submitter evidence. Since I prepared my evidence on behalf of submitters has been lodged. I have reviewed the submitter evidence, and in particular the evidence of Ms. Susanna Tate insofar as it relates to heritage matters, including the attached letter from Mr. John Brown. Ms. Tate's evidence raises the following matters of relevance to my assessment: prohibiting the use of the buildings until repairs and investigations are carried out, and the proposal of a bond for repairs and investigations into the condition of the buildings. In his letter, Mr. John Brown has suggested an event management plan to mitigate risk to the buildings and site, the proposed material of the acoustic fence, the potential impact of the acoustic fence on the connection between 67 Speargrass Flat and Thirlby Domain, the potential for the acoustic fence to obscure views from publicly accessible places, and impacts on archaeology. I'll respond to these matters in turn. At paragraph 59, relying on the comments made in my evidence, Ms. Tate suggests that the use of the buildings should be prohibited until repairs and investigations are carried out into their condition. I disagree with this suggestion. On behalf of the applicant, I carried out a visual inspection of the site to assess the general condition of the buildings and to provide an outline of maintenance requirements. The intention was to indicate the repairs and maintenance that would be required over the next 2 to 5 years, and the considerable investment the applicant undertakes in maintaining the property. Largely, my concerns involve repointing stonework, repairs, the replacement of building elements, for example, replacing the posts supporting the lean-to to the farm shed, with more major repairs required in the cow byre and timber cottage, neither of which are proposed for use for temporary events. The entirety of the maintenance and repairs were described as substantial due to the size of the site and the likely cost of these repairs, which require specialist input and tradespeople. During my inspection, I did not believe the buildings to be unsafe. At paragraph 59, Ms. Tate has also suggested that the applicants be bonded to the value of $250,000 to undertake repairs and investigations. I have no knowledge of a similar requirement being placed on similar sites and do not believe this to be reasonable or equitable. At paragraphs 57, 58, and 60, the state has also suggested a condition. The consent condition requires reinvestment into repairs and maintenance commensurate on the level of use of each building. This suggestion is impracticable. There is no certainty that the use of each building would correlate with the repairs needed, and more funding may be required for each building due to its construction and size, etc. I also believe that this suggestion goes beyond managing the effects of the proposed activity on the environment. At paragraph 61, Ms. Tate outlines the proposed panels and not a condition of consent. I understand that a condition is proposed, as Mr. Gibbons, I believe, has described. The state also suggests conditions at paragraph 123, reaffirming the suggestions outlined above and adopting the conditions outlined in Mr. Brown's letter. These are discussed further below. At page 4, Mr. Brown outlines that there is nothing in the application from a heritage perspective that could not be managed to avoid risk of impact or damage to the heritage buildings, but accidental damage may still occur. I agree with this comment. Accidental damage can occur to any heritage building or site. At page 4, Mr. Brown also suggests an event management plan to mitigate the risk to the building and site, which defines routes for pack-in and pack-out vehicles with spotters to monitor vehicle movements within 5 meters of the stables, cow byre, cottage and ruins, No temporary buildings or structures to be erected within 1 metre of the ruins, and parking to be prohibited within 2 metres of any heritage building. All these are sensible suggestions, but I believe the applicant should be able to manage the site and adapt this management without prescriptive conditions being set. At page 5, Mr. Brown agrees with Mr. Nott's recommendations on the construction of the acoustic fence. I refer back to my comments at paragraph 21 above, outlining that either a stacked schist or a stacked schist and weathered timber fence could be appropriate given the materials on the site. At page 5, Mr. Brown also considers that an acoustic fence will have a minor impact on the visual relationship between Ron Gordon's homestead at 67 Speargrass Flat Road and the Thirlby Domain buildings. As outlined in paragraphs 17 to 18 above, I consider that the heritage significance of Thirlby Domain is due to its association with Hallenstein and the cohesive nature of the historic farm buildings and ruins. While the properties may have a modern association and a visual connection due to the proximity, this connection does not equate to heritage significance as assessed under chapter 26 of the district plan. At page 6, Mr. Brown has reproduced photographs of the site, and I believe that he hasn't actually visited the site. Both appear to have been taken from private land, whereas the focus of chapter 26 is on views from publicly accessible land. Based on the current view shafts of the heritage features from the publicly accessible places, the only view impacted would be where approaching the property from the east along Speargrass Flat Road. Mr. Nott also addressed this and proposed additional landscaping. As outlined in my evidence, I have no issues with landscaping proposed by Mr. Nott. At page 7, Mr. Brown has queried the impacts on archaeology due to the use of the site and the construction of the acoustic fence. Thirlby Domain is not an archaeological site listed in section 2612 of the district plan, and as such, rule 26.5.18 is not relevant to a proposal. I am unaware of any subsurface features that might be affected by the proposed use of the site. However, if there was an effect on buried remains, any effect would be less than minor. The archaeological value of the site is primarily in the buildings. While there may be potential to impact archaeology, particularly with the construction of the acoustic fence, the extent of this is best assessed in an archaeological assessment. In my view, effects on archaeology are best managed under the Heritage New Zealand Act 2014. I propose that the application of this Act is included as a guidance or advice note. In summary, nothing raised in the submitted evidence causes me to reconsider the conclusions reached in my primary 2nd of September evidence. I maintain the view that the proposal is appropriate for the site from a heritage conservation perspective, and that if these important historic buildings are to be maintained, cared for, and enjoyed in the future, the proposal is an ideal way of providing them with a use that does not require their substantial change or development. Thank you.
Thank you very much, Mr. Miller. I might just start. I'm interested in your, and I think you're covering this at paragraph 20, but can I just tease this out a bit further and with you? And that's the relationship with what appears to be some entrance gates and the cattle, which has got the cattle stop on it on number 67 Speargrass Road. Were they the original entranceway into the farm, into these buildings on the other side of the property? Were they?
Sorry, which one are we talking about on the road frontage to 67?
So inside the property at 67.
Yeah.
If you go to the property there, you'll see there's like an entranceway, there's a cattle stop in it. And essentially that's the logical way that was the entranceway into the barn buildings that went through there. And now there's the boundary. Was that unlogical? Was that constructed at the same time as the?
I don't know, I'm afraid. I've confined myself to the heritage buildings that form part of the listed heritage feature. I know that the Ron Gordon dwelling was built in the 1950s or something like that, but I haven't looked in depth into that site and any access or anything like that through in the past.
Because I wonder, and that's why I'm just interested in your views. I wonder if they were linking, that was the original entrance into the stables and into the barn, was through an access way that originally went over what is now 67 Speargrass Road. I just wondered what the relationship between those two were. If you don't know, you don't. And then, because the next question I was going to ask you was then, would that relationship then be severed by the construction of this fence?
Well, I think you need to have a look at the identified heritage values. So those are the heritage values which I presented in my evidence and in the heritage impact assessment, which I believe and Mr. Brown have accepted. They're also in line with the heritage assessment, which is available on the Heritage New Zealand website. And all of those relate the heritage values of these buildings and the ruins to Hallenstein and not to the mid-20th century Mr. Gordon building.
No, I totally think if you go to Mr. Brown's left, or whatever the appropriate word is, he has some photos there. He has a picture of the Gordon house there. And then below it has those schist walls that I'm talking about, which look like an entranceway. If you go, it's on page 6 of his letter.
Yeah, so we're talking about a black and white photograph at the top there.
And the one below it, you
yeah.
see how that little, there's a little cattle stop in there. Were those originally the entranceway into the barn?
Doesn't look, I mean, that's the colour photograph, that seems to be much more modern, and that doesn't seem to be present in the black and white photograph of. So I would say that's a much more modern alteration.
Because I'm just trying to get my head about if that was part of the original construction or not.
No, I can't really see. I mean, it's I'd be very happy to take a much better look at a much higher resolution image of this black and white one there, but that seems to show also sort of continuous.
Yeah. So
front there. So as the Gordon house was built in the 50s, I would imagine that the access has always been through the site, from the ruins direction, and then this homestead was obviously being added on at a much later date.
Okay, well, maybe something that one of Ms. McDonald's witnesses can pick up, because I'm just interested if they were constructed at the same time, if then, as I say, what the implication of the fence would have in terms of that connection between the two. But if you don't know, you don't know. That's all good. Thank you. Over to you, Commissioner. Do you have any questions of Mr. Miller?
I would just like to understand this landscaping that you have proposed. So this colour photograph is actually quite handy for that. I understand the fence is to start at the edge of the stables building, is that correct?
Yes, yes, yeah.
So it starts on the right-hand side of the gable facade that we're looking at?
Yeah.
Yes, and is your landscaping proposed to the left of that, or is it along the Speargrass flat?
So my understanding that this is an issue because I attended site when Mr. Knott was there, that he felt there could be some additional landscaping added between the termination of the fence and the boundary with the road.
Right, okay, that's clear. Sorry, I got confused as to who was proposing it. You're right, that was Mr. Knott. Okay. I'm interested in the, obviously there's a huge cost to this upkeep, and you have said in various places things like it's unrealistic to rely on a private owner who can gain no benefit from the property. However, the evidence we've heard from the applicant is that they will actually gain very little and it will no way cover it. So I suppose what I'm really interested in is this enough to maintain these heritage buildings, or is actually a lot more gain needed?
The thing with heritage buildings is that they're always going to need maintenance, and so and it doesn't really happen in New Zealand yet, although it is coming for us overseas. There's an idea of a quinquennial inspection whereby you're sort of preparing a 5-year maintenance plan, and then planning out what you're doing at the end of 5 years and reassessing the next 5 years and so on, and then you can forward plan. Now, if you can build up that sort of maintenance system on buildings, then obviously that's your most cost-effective method of maintenance. Reactive maintenance or deferred maintenance is always going to be more costly. So these are farm buildings. They're not meant to be perfect in any way. So the proposal will provide an income for them, and it will provide a use for them. And what's really important about use of buildings is that once buildings become appreciated and valued, then there's that incentive to look after them.
Sure. And then just a question about the wall. So you say in paragraph 21, I consider either a stacked schist and whether timber or schist and whether timber could be appropriate with the change in construction method and materials, insisting in reducing the bulk of the fence. Why do we want to reduce the bulk of the fence?
I just thought something that would visually break up the wall a little bit. One wall that's long and of uniform height. Having some features, whether it was reducing down the ends of it gradually, or sometimes walls will have buttresses or something like that. It just breaks them up.
I understand what you were saying now. Yeah, not understood. I have no further questions. Thank you, Mr. Miller.
Thank you, Mr. Miller. Thank you very much for your time.
Excuse me.
I think,
Sorry.
yes, Mr. Hay.
Yeah, I was going to say, we're up to Mr. Hay now. Thank you. Good afternoon, Mr. Hay.
Good afternoon, Commissioners.
Really, we're over to you.
Wonderful. I assume my evidence in chief is taken as read. Would you like me to start at paragraph 8 of my summary?
That'll be fine. Thank you, sir.
Wonderful. In my evidence, I considered noise effects arising from the proposed temporary events at several locations within Thirlby Domain. The number of event locations within the site and the use of buildings and landscapes is unique in my experience and adds a degree of complexity to the application that is reflected in the acoustic and planning evidence from all parties. The proposal is for up to 100 events in a calendar year. Up to 12 of these events may occur between 2000 and 2300 hours within the Red Barn farm buildings or the stables. Regardless of the time of day or location, controls on the noise level, scale, and character of the activity are proposed via noise limits, limits on the number of guests, or other management means via proposed noise management plan. A detailed noise management plan has not yet been prepared, but Mr. Giddens has presented a set of proposed consent conditions for the activity, and I have described the activity as it relates to noise in my evidence between paragraphs 16 and 23. In the event of any differences between my evidence and the proposed consent conditions, the consent conditions which I have reviewed and agreed with should be considered definitive. Daytime events as proposed will comply with the proposed district plan noise limits and will result in effects that I consider less than minor. Nighttime events held within the stables are also predicted to comply with proposed district plan noise limits. These events are intended to be low-key nature, such as a dinner or similar, where background music may be provided with strict limits. Nighttime events with music considered appropriate for dancing will be held only within the Red Barn. These events are likely to exceed the permitted proposed district plan noise limits at night, in particular at dwellings within the lifestyle precinct zone, which have a site boundary rule, but also at one dwelling within the rural activity zone. To put noise effects from the proposal as a whole into context, if the 12 evening events at the Red Barn were removed from the proposal, or if music level was further restricted, then the proposal would meet the permitted daytime and nighttime noise standards in the proposed district plan. I have assessed the ability of the Red Barn to provide some sound insulation against high-tempo rock music with a strong bass beat. These measurements have been used to calibrate my predictions of noises surrounding receivers using industry-standard methods. I have assessed noise effects at nearby dwellings. As part of this process, I have considered the existing environment, activities that the district plan permits in the area, the noise level and character at or within the notional boundary of those dwellings, the frequency, duration, and time of day at which noise from temporary events will be experienced, the potential effects arising because of predicted noise annoyance, and that's annoyance or sleep disruption. Below, I summarise my reasoning with respect to the considerations I listed above. The WBRAZ and the WBLP differ in that the lifestyle precinct has a site boundary compliance rule for noise, whereas the rural activity zone uses the notional boundary. Both set relatively low daytime and nighttime noise limits, and both define the onset of the district plan night as 2000 hours, rather than the more typical 2200 hours used by most districts in New Zealand and implied in the WHO guidelines. Within both zones, the proposed district plan permits an extensive range of temporary activities that generate daytime noise of the same character as Thirlby proposed, but potentially greater level and duration. Even absent these temporary events, the areas, as demonstrated by Dr. Trevathan's evidence at his paragraph 7, is not particularly quiet at all times. The character of noise generated will be some combination of guests' voices, music, and vehicles. For any given receiver, this will vary in level due to both the scale and nature of the event and the location on site at which it is held. For example, Thirlby hosts outdoor weddings with fewer than 10 guests and no music of note lasting less than 2 hours, through to larger events that may use the Red Barn at night and include loud amplified music. Other events such as corporate dinners, garden parties, or car rallies have been described as having occurred on site previously. Not all these events will occur at the same location within the site, with the result that both the level of noise and its potential to be intrusive will vary at any given receiver. This is a unique feature of Thirlby domain in my experience, and makes any cumulative assessment of noise over a year at any given receiver impractical. Instead, I have assessed all events as being of the maximum permitted size and duration at the noise levels I have predicted. The exceedance of the proposed district plan nighttime noise limit by some events makes the activity status non-complying with respect to noise. In considering the effect of these nighttime events, I have focused on the Red Barn, as this location is proposed to allow music for dancing, which represents the application's worst-case scenario for noise. While the proposed district plan defines the onset of night at 2000 hours and provides for a 40 dB LAEQ noise limit, this is not, in my view, an appropriate basis for assessing effects as opposed to compliance. I am joined in this view by Mr. Exeter, QLDC's acoustic consultant. Instead, I consider that there is not a realistic loss of sleep amenity between 2000 hours and 2200 hours, and have instead assessed against annoyance guidelines in the outdoor living areas of dwellings during this timeframe. This has been Mr. Exeter's approach also. The predicted daytime noise levels from temporary events fall short of the WHO guidelines for the onset of moderate annoyance. Similarly, both Mr. Exeter and I have assessed the potential for sleep disruption in the proposed hour of operation after 2200 hours. As the predicted noise levels are only marginally above the applicable guidance for sleep amenity at 4 dwellings, and for just 1 hour at the beginning of the sleep amenity period, I am satisfied that any adverse noise effect would be less than minor. I have concluded that, subject to satisfactory controls, which will have been detailed by Mr. Giddens, the noise effects on the proposal are less than minor and that the noise is not unreasonable. Turning to submitter evidence, essentially since I submitted my evidence in chief, Dr. Jeremy Trevathan has provided acoustic evidence on behalf of several submitters. The evidence raises the following matters of relevance to my assessment and/or evidence: the ambient noise level and character in the absence of temporary events, perceived gaps in information about the application, noise mitigation, and noise management. I respond to these matters in turn. At paragraph 7 of his evidence, Dr. Trevathan describes the residual noise levels in the area over 2 days. Both qualitative and quantitative descriptors are consistent with my own experience at the site. To fill some of the information gaps that Dr. Trevathan is concerned about, I can confirm that measurements of the sound reduction of the Red Barn were made as described in paragraph 14 above. These measurements were made under conditions consistent with meteorological category 5 as described in NZS 6801. This is best described as slightly enhanced noise propagation conditions and is the upper range of the meteorological window used for compliance measurements. These measurements were used to calibrate modelling of noise predictions for the Red Barn events. All noise predictions were carried out using MDA's modelling software Minerva, which implements international standard ISO 9613 Part 2 1996, Acoustics Attenuation of Sound During Propagation Outdoors, Part 2 General Method of Calculation. I assumed that both barn doors would be closed, which is required by the proposed condition of consent except for access. I note that both doors are standard personnel door access doors, one of which faces onto outdoor area 2 and the other to the north facing away from receivers. Even if the doors were open, given the directivity of the north door, poor sound insulation of both the doors and the barn, the large radiating surface area of the barn, and the small surface area of the doors, leaving the doors open would have an imperceptible effect on received noise level. At paragraph 12, Dr. Trevathan queries an inconsistency in the noise levels at receiver 12 due to nighttime events at the Red Barn, with an apparent change in noise level of 10 dB from the initial RFI letter compared to my evidence. This is due regrettably to an error on my part. In table 1 of the RFI letter, an internal noise level of 95 dBA was assumed, while in table 2, an alternative noise level of 90 dBA was considered. A sharp-eyed observer, such as Ms. Walt, would note that the noise level increased by 5 dB rather than decreasing as it should have done. In my evidence, I have corrected that error. I do not share Dr. Trevathan's concern that events at Thilby Domain may be audible at some receivers on many occasions. As I have noted, depending on the scale and location of the event, some receivers will certainly find the events more audible than others, but in reality, not every event will be a maximum capacity event and all at one location. More importantly, in my view, such noise is clearly anticipated by the proposed district plan during daytime hours. Thilby itself, as it consists of 2 sites, could host 14 temporary events for up to 500 guests, excluding pack-in and pack-out, and including a generous allowance for helicopter movements, among other factors. In addition, each of the neighbouring properties can undertake such temporary events, 7 per site. Thus, this character and scale of event forms part of the daytime environment. I'd also note that audibility is not an assessment criteria and never has been in New Zealand. I disagree with Dr. Trevathan's analysis at paragraph 17.1 that it would be consistent with best practicable option for events not to be held at Outdoor Area 1. While we agree that the location is close to a neighbour, I consider it unlikely that 100 events will be held at this location, and in fact the latest proposed consent conditions restrict the number of events to no more than 24 per annum. More importantly, a best practicable option analysis must consider non-acoustic matters. I note that Outdoor Area 1 is a sheltered, flat, grassy area with excellent sun access in a photogenic setting, making use of unique listed buildings, and this undoubtedly makes it desirable for some users. The applicant has taken advice offered by me that the events must be mitigated in this area. Mitigation includes restricting the number of guests, the time of day, the maximum duration, maximum music noise, and the location of any loudspeakers or performers. That's in addition to restricting the number of events in that area. In addition, the applicant proposes to construct a noise control barrier consistent with the heritage setting. At his paragraph 17.2, Dr. Trevathan expresses the view that some form of respite from nighttime events may be required. I agree this can be useful. The latest proposed conditions prepared by Mr. Giddens makes provision for this through restricting the number of times per month evening events can be held on 2 subsequent days and weekends. At his paragraph 18, Dr. Trevathan expresses concern regarding late night events at the ruins. As per my evidence at paragraphs 53, 55 and 106, nighttime events at the ruins are no longer proposed. At his paragraph 20, Dr. Trevathan is concerned that if 2 events were to occur on the same day, the 6-hour duration could inadvertently be exceeded. I agree that as currently worded, the proposed consent condition permits multiple events per day, although not at the same time. I do not share his concerns regarding temporary events inadvertently running over the 6-hour maximum duration. This is a matter that the applicant can manage appropriately, no different to managing operating hours. I agree with Dr. Trevathan that the complexity of the site with multiple locations, strict limits on noise from loudspeakers, number of guests, etc., will require a good level of attention and oversight from the applicant to ensure compliance. I'm comfortable that these matters can be worked through and documented in the proposed noise management plan, which council must certify. At his paragraph 28, Dr. Trevathan notes that he could not find Mr. Exeter's helpful suggestions. Mr. Exeter referred to the control of music, sound level and character, plus the need to have measurable noise levels in both his section 3 and 6. Being familiar with Styles Group's approach to similar issues for other proposals involving music for dancing, etc., I interpreted these comments broadly to also include a level limiting device for use at the Red Barn. This is proposed. In summary, nothing raised in the submitted evidence causes me to reconsider the conclusions reached in my primary evidence. I maintain the view that daytime noise levels are capable of compliance with the district plan standards, and that nighttime noise levels from the Red Barn, while not complying at the lifestyle precinct site boundary, will result in noise levels that permit an acceptable and good standard of amenity consistent with accepted guidelines. In my view, the noise effects arising from the activity will be no less than minor, and the noise level and character are not unreasonable. Thank you.
Thank you very much, Mr. Hay. Do you have any questions for Mr. Hay?
I've heaps of questions for Mr. Hay.
Off you go then.
I guess my first question is about the fence. So the fence is quite important. Obviously the fence is not only an acoustic consideration, but it's also a heritage and a visual amenity consideration, and it's contested by the owners of particularly 67 Speargrass, that they are not that keen on the fence. If the fence were not constructed, what effect would that have on your evidence?
It would mean that events held at Outdoor Area 1 would be between 10 and 12 decibels greater in noise level at that receiving property.
At 67, it would have no effect on any other properties?
Correct.
So would that essentially make outdoor area 1 an unacceptable use in your view?
I don't think I would go as far as to say unacceptable. I think it would further restrict the size and scale of events that could be held there without reaching noise levels that may be unacceptable.
Okay, so they're receiving 9. I was just having a look at the numbers to see where they would end up. 2.
So a maximum scale of event currently with the fence in place, I'm predicting 47 dB. So if you took that fence away, that would end up being somewhere around 57 to 60, and it would be largely people noise, the sound of voices, people talking.
Yeah.
So you would have to further restrict the size of the event that could be held in outdoor area 1 in the absence of a fence to keep the noise level somewhere close to 50 odd. Or you may restrict the maximum duration so that the rating level is further reduced as well. There's a variety of mitigation measures that could be undertaken and still use the area.
And the red barn?
Well, the red barn's not affected by the fence.
Not at all.
Not at all. We've got the cow buyer and the stables intervene. There's substantially larger screening than the fence.
Okay. The notional boundary and boundary issue. So the PDP has obviously recently been adopted. It's gone through its statutory process, quite a thorough process, and the boundary of the lifestyle precinct has been considered the correct location in terms of the PDP for measuring noise. Yet you're telling us, well, it's excessive to measure it there. That's just and the same really is going for the nighttime noise limit starting at 8 o'clock rather than 10 o'clock. So the PDP has been through a process, this has all been established, but you're telling us, well, they're wrong.
Well, it depends whether you're talking about compliance or assessing effects. I agree that the PDP is the correct tool to use if you're assessing compliance, and the result of exceeding the district plane noise limit is that the activity is non-complying with respect to noise, and at that point we move on to consider effect. And the district plan is one part of considering effect. It's not the only way of considering effect or the only guideline or tool that we have to consider effect. So, and just as an aside, on a different consenting matter here in Queenstown recently, I expressed the view that 2000 hours was a very conservative onset for nighttime, and the Queenstown planner asked me why the district uses 2000 hours, and I said I don't know. It is very conservative, and I've never found anyone who could give me an answer. And so while it has been through a process, I couldn't tell you that that there has been any great attention or effort put into analysing why that nighttime occurs at that particular time, but it is what it is, and we acknowledge that and then assess effects regardless. So the reality is that between 8 o'clock, 2000 hours, and 10 o'clock, 2200 hours, those are not recognised times for protecting sleep amenity. And yet that is what the nighttime noise rule is designed to do. It is to protect sleep amenity. So when assessing the effects, that is why both Mr. Exeter and I set aside the nighttime noise limit between 2000 hours and 2200 hours because there is no sleep amenity to protect at that time. There is outdoor use and arguably also indoor use, but if you protect outdoor use, you protect indoor use.
So does the district plan say that the nighttime noise limit is to protect sleep and amenity? Is that in the district plan?
No, it's not in the district plan. That is a combination of 6802 and the World Health Organization. That's where the noise limit comes from.
So just picking up my colleague's question, the converse of that is then, because you talk about compliance with these rules are less than minor, if that's not the thing, if it's not about compliance, how do you know that the effect is going to be less than minor at the lower time?
Sorry,
Well,
I might be misinterpreting what you've said, but I haven't assessed.
No, go on, I interrupted you, please.
I've conducted my assessment on the basis that during the period from 2000 hours to 2200 hours, I'm assessing against World Health Organization guidelines, and that's for the onset of moderate annoyance outdoors and outdoor living spaces associated with dwellings. And then from 2200 hours onward, I've assessed against a requirement for sleep amenity, which again, both the nighttime rule in the district plan and World Health Organization provide for.
Okay, so question which Mr. Giddens referred to you. It was relating to conditions, if you have those in front of you, the conditions that Mr. Giddens provided this morning.
I do.
Condition 19.
Yes.
So the consent holder shall ensure temporary events do not exceed the following noise limits. And you have informed us through your evidence that it is predicted that the daytime noise limits will meet the district plan requirements, but this condition is actually for a louder or a more sound, more noise. Is that intentional or is that an oversight?
No, that's an oversight.
So we should remove the word notional?
I think you would say perhaps I'll confer with Mr. Giddens about the best wording, but I would think that you would add to the end of that sentence so that it reads outside the property in the WBRAZ or site boundary for the WBLP, but would need to make sure that wording was correct.
In your evidence, in your executive summary at paragraph 13, you have said that you've set out what the permitted activities are, the 7 events that we've heard about with 500 people for 3 days, and you've said neighbouring sites have permitted the same activity, and then you've said this forms part of the existing environment against which I have conducted my assessment. Can you explain to me how you incorporate that into your assessment?
So that's looking at the range of activities, their nature, their scale, the types of noise that they may generate in terms of both character and level, and the general noise associated with that activity. So it's giving me an understanding when conducting my assessment as to whether the type of sound that Thirlby Domain is likely to generate is consistent with what the district plan envisions and promotes.
So it's really only about the type of sound as a general concept rather than the quantity of sound.
No, it's definitely both.
Yeah, you haven't, yeah, okay.
Well, without knowing the exact number and scale and type of event that every site in the immediate neighbourhood may run, you can't conduct a quantitative analysis.
just checking if I have any more questions for you. Yes, the national planning standards require that the new district plan adopt NZS 6802. Now, this may be a question for Mr. Gibbons, but how does that fit into us in this district being in the middle of a planned review?
I think it's a moot point because QLDC adopted 6802/2008 some years ago.
Well, I assume that you're making the point. I assume that this was this followed through into your issue with the notional boundary and the boundary and the 20 versus 22 hours, or am I mistaken that that would automatically follow through?
Sorry, I'm just groping for context a little bit. Which are you talking about?
It's your paragraph 31 of your evidence, and my understanding was that one of your reasons for raising this was to demonstrate that the Queenstown Lakes District proposed plan is conservative in both its timings and its methodology for measuring noise in the lifestyle precinct. Am I mistaken that if you adopt NZS 6802 in accordance with the National Planning Standard requirements, you would automatically adopt 10 PM as the nighttime noise limit, and you would automatically adopt notional boundary measurements?
You would be mistaken in assuming that the National Planning Standard requires the adoption of the 2008 versions of both 6801 and 6802. It requires the adoption of the LAEQ parameter, but it leaves most other matters up to district plans to determine.
Oh, so it only required a partial adoption of it?
Well, the standard doesn't specify 2200 hours. It sets that as a guideline template for new district plans, but it leaves it open to districts to carry out some analysis.
Thank you. Can you explain the averaging of daytime sound, which you've addressed in paragraph 35? I just didn't quite understand what you were saying there.
Sure. So when you measure a sound, and for simplicity, let's assume that it's a constant sound for a defined period of time, and for simplicity for this event, we'll say 6 hours because that's the maximum duration proposed here. You do a number of things. You first measure the sound itself using 6801 and do that in a compliant way. Then you consider the level of background noise and make sure that the level of background noise is not so high that it artificially increases your measurement of the sound that you're interested in, the activity sound. If they are too close together, you can make an adjustment for that. You then consider the character of the sound that we're interested in and decide whether it has what is called a special audible characteristic. We usually just call it SAC, and whether that is sufficient to require that the sound is penalised in some way. And the two most common causes of penalty are impulsive character, which you can think of as isolated bangs or thuds or thumps, or it could be tonality. And so it's not whether those characters are present at all, it's whether they are present at a level sufficient to warrant a penalty. And if you judge that penalty is required, you add 5 decibels to the sound. And then there is a duration requirement. And so the standard talks about a prescribed time frame, which defaults to the daytime period of the district plan, but it can vary. For instance, if there is a consent that specifies different hours of operation, that becomes the prescribed timeframe. And if the sound of interest is present for less than a certain percentage of the prescribed timeframe, then you are allowed to discount the measured noise level by a certain amount, up to a maximum of 5 decibels, but it can be less. And in our case, it's less. And so the rating level that is compared against the district plan limit is a combination of your measured level, less any duration averaging, plus any penalty that is applied for special level character, minus any adjustment for ambient noise for general background.
I understand it now, thank you.
Just for my colleagues working away through her notes, just picking up the point, and you picked us up in your evidence in chief as well, where you talk about moderate annoyance, and you talk about the WHO guidelines. Is there a scale that sits on?
So moderate annoyance is at as low as the WHO goes. So they go from moderate annoyance to serious annoyance. And I should note that those are onset levels for the vulnerable portion of the population. WHO don't particularly clearly define who might be considered vulnerable, but they're talking about the elderly, the sick, the very young, people who are likely to be more sensitive to noise on a community basis rather than an individual basis. But they don't list anything under moderate annoyance. That's
the lowest scale they have, because I'm just interested in how that, because that word by its definition doesn't sort of seem to me be less than moderate, but that's the bottom end of their scale, is it?
Correct. And as I say, that's onset level.
So it goes moderate, and then does it goes anything? Is it just moderate and severe, or is there?
It's the onset of moderate at 50 dB for 16 hours, and then serious annoyance onset is 55 dB for 16 hours.
Serious, okay. Because I'm just going to say, is that sort of the convention that's been adopted, shall we say, for better use of words, amongst noise experts, that moderate in this context actually means less than minor in an RMA context?
I don't know that there is a universal agreement, but I think that's a common agreement.
Okay. Thank you. Thanks very much. That explains that quite simply.
I only have one more question. Paragraph 109, you've said the only issues outstanding between Mr. Exeter's assessment and mine are a full consideration of the permitted baseline.
Yes.
So in what way have you considered the permitted baseline?
Well, I described how I had worked through the permitted baseline earlier in response to your earlier question. Mr. Exeter did not consider the permitted baseline. He's alluded to the fact that he understood there was some dispute as to what the permitted baseline was, and he moved on from that. He didn't consider it. So that's where we differ, in that I have considered it, he hasn't.
But you explained earlier to me that your consideration was merely to look at what kind of noise might be anticipated by the district plan, not to quantify that in any way.
Correct.
So it's a fairly minimal difference, really.
Yes, correct. Yep.
Okay, I have no more questions.
Just one last for me. When we're going back to those guidelines about 10 o'clock or 12 or 2200 hours, as for sleep, is that aimed at adults, or does that take into consideration children and things like that, or is it predominantly aimed at adults?
WHO doesn't actually define that. My experience in this region has been that if you can get a kid to sleep in midsummer before 2200 hours, you're doing pretty well. It's still daylight outside. They seem to be quite resistant to settling down, but regardless, I think you can achieve an appropriate sleep amenity indoor levels we're talking about.
That WHO doesn't make any specification between adults and children. It's just that's the sort of time it's just. Okay, thank you.
Correct.
That's all from me. This is anything else from you?
No, I think that's it. I was just
hold on
the
just before we.
just in case there was anything in here that we needed to discuss. But I don't think so. I think we have dealt with it all. No.
Thanks very much, Mr. Hay. Really appreciative. Thank you. Very helpful.
Thank you.
Shall we take the break for 20 minutes and come back and then go to Mr. Gibbons?
Yes.
Okay, we'll stand adjourned for 20 minutes. We'll come back just after 20. Yeah, so it's 3 o'clock at that bang on time. So we'll come back at 20 past and we'll go from there.
This was Jane said day one as well, so I just assume you made it. Did not.
Oh, it does. Yeah, sorry.
No, it's what I
know what you meant.
Oh,
well, I do what you meant too, but this one here, Ben Gesson.
Ben
Sorry, Ben
Greaser.
Wendy, you guys mutes off.
Welcome back, everyone. I hope you all had a nice break, nice cup of tea and such like. So, I think where we're now at is we're now with Mr. Giddens, if that's correct.
Yes, good afternoon again.
Good afternoon. Welcome to having you back. So,
It's not too clear, is it?
yeah, and we've got the conditions. I've got those out as well. So, over to you. Thank you very much.
Great. Would it be helpful for me just to run through the summary for a start?
Yeah, that'd be lovely. Thank you.
I'll start off at point 6 there.
Yes, that'd be great. I think we know who you are.
Right. In my planning evidence, I consider the proposal for temporary events at Thirlby Domain against the relevant planning provisions. A number of amendments have been made to the proposal, in addition to an updated set of suggested consent conditions that provide further measures to help avoid, remedy, and mitigate potential adverse effects. The application overall was for a non-compliant activity because of breaches to the nighttime noise standards for up to 12 evening events held in the Red Barn. The application remains this activity status, irrespective of any determination on whether the proposal was for temporary events under Chapter 35 or any commercial activity not otherwise provided for under Table 24.1 of Chapter 24. The key issues, in my opinion, is the proposal for temporary events as defined, and where does it sit within the framework of the PDP? Are the effects of the proposal no more than minor? Is the proposal contrary to the relevant objectives of the plan? And are the conditions proposed appropriate to avoid, remedy, or mitigate the effects? In my opinion, the proposal is for temporary events as defined, and the PDP directs that consent for a discretionary activity is required under Rule 35.4.16 because the permitted activity standards under 35.4.5 are not met, and that's obviously notwithstanding the overall status still remains non-compliant. And I explain my rationale for this in Part 5 of my evidence. The relevant objectives and policies of Chapter 35, which is temporary activities, Chapter 26, historic heritage, and Chapter 36, noise, are those that I consider most pertinent to the assessment of the application, which is directed by Chapter 35 itself. My evaluation also includes the assessment of the objectives and policies of Chapter 24, and I should also note here the strategic objectives and policies under Chapter 3 as well. And I've concluded that overall the proposal is consistent with the desired policy outcomes. It's certainly not opposed in nature, repugnant, opposite, or antagonistic to the relevant objectives and policies in my view. In terms of what the activity is, this issue becomes largely relevant to the gateway test under Section 104D is met. This is where I've landed with my assessment on the whole, whereby both limbs of the test are met. With regard to the consent conditions, I have provided an updated suite of those contained from the Section 42A report and based from some helpful input from the submitters, planning and acoustic experts. I've also taken guidance from what I understand to be the most recent consents authorised by the Council to ensure that there is some consistency in key matters, such as the recording of event details, details to be included within the noise and operational management plan, the use of calibrated systems to reduce noise and noise monitoring procedures. My assessment in Part 8 of my evidence considered the effects on the environment with reliance on the technical experts and the evidence of Mr. Hay, Mr. Miller and Mr. Bartlett, and also in consideration of those relevant objectives and policies. In my opinion, the key effect from temporary events is that arising from noise, including people noise, vehicles and music, and the consideration of the amenity of the directly nearby neighbours. And I'll just make it clear that I'd say that those issues are exactly the same if the activity was considered as a temporary activity or a commercial activity. The plan sets reasonable limits through its noise standards, which is only recently reviewed and made operative, as Commissioner Baker noted, which indicates the standard of amenity of within a zone. In my experience, the effects from permitted noise are accepted as being part of the environment. While this may in some instances give rise to nuisance effects and disturbance, it would be difficult to say that such noise is unreasonable. As an overriding requirement, every person has a duty under Section 16 of the Act to avoid unreasonable noise. In this instance, the daytime noise from the temporary events will be permitted, and the noise experts appear to all be in agreement that the noise effects from the proposal will be acceptable. Conditions of consent have been suggested that will assist with minimising nuisance effects. That includes lighting and the noise and management procedures as well. Mr. Hayes succinctly put the noise effects in context in the summary. If the 12 evening events at the Red Barn were removed from the proposal, or the music level was further restricted, the proposal would meet the daytime and nighttime noise standards in the PDP. Mr. Hay concludes that the predicted daytime noise levels from both temporary events fall short of the World Health Organization guidelines for onset of moderate annoyance. Both Mr. Hay and Mr. Exeter for the council have assessed the potential for sleep disruption in the proposed hour of operation after 10 p.m. As the predicted noise levels are only marginally above the applicable guidance for sleep amenity at 4 dwellings, and for just 1 hour at the beginning of the sleep amenity period, Mr. Hay is satisfied that any adverse noise effect will be less than minor. He's concluded that, subject to satisfactory controls, the noise effects of the proposal are less than minor and the noise will not be unreasonable. With regard to heritage effect, I've concluded in my evidence, based on the evidence of Mr. Miller, that the proposal represents a sustainable use of the heritage buildings in a heritage setting. Positive effects will arise through the continued repair and maintenance of the buildings and property, supported financially through funds from temporary events. With regard to traffic effects, I've also concluded, based on the expert evidence of Mr. Bartlett and also Mr. Hewlin for the council, that traffic effects can be appropriately managed and will be no more than minor. My overall view of the effects of the proposal is that they are no more than minor. I've reviewed the submitter evidence prepared on behalf of several submitters from Ms. Tate, and including the heritage report appended to her evidence, and also from Dr. Treverthen. I found some of their comments relating to conditions helpful. I note that the Section 42A report contained a number of conditions that had been previously discussed with the council that responded to a number of the concerns noted by submitters, but I understand they may have been overlooked. With regard to Ms. Tate's planning evidence, it appears that we're generally in agreement with regard to the effects of the temporary events on the surrounding environment being minor or less. Ms. Tate has tagged most of her conclusions, however, and I've deduced from her evidence that her primary issue is the cumulative impact of the temporary events based on her account of a non-fanciful application of the proposal. I do not agree with Ms. Tate's assumptions on how the consent, if approved, would be operated, and consider it as an unrealistic picture. Ms. Tate agrees with my permitted baseline as it relates to commercial recreation activities. She does not agree with the application of the permitted baseline as it relates to the 2 sites that make up Folby Domain. This part of my baseline is factual, reflecting the definitions and rules, and also reflects how the events have been run in the past, i.e. the ruins is on its own site and separate to the groupings of heritage buildings on the other side. This permitted baseline has also been accepted by the council when it come to evaluating what can be undertaken on the property as permitted activity for compliance purposes. The permitted baseline, in my view, represents what the applicant could do with the property and is not fanciful. While part of it may not align with what they wish to do with the property at this point in time, it certainly does not preclude it from occurring in the future and is relevant to my opinion. The permitted baseline is also useful when it comes to the use of heritage buildings in outdoor areas. The PDP does not sterilise this property from use because of its heritage status and various protections, and there is no expectation that the area of the property adjoining 67 Speargrass Flat Road in particular will have no daytime activity, which appears to be the starting point that the submitters' experts have taken in their consideration of effects. If this area of the property was used for one of my hypothetical examples, then the reality is that there could be very frequent use of this part of the property for a number of days a week, with effects that are, in my opinion, not too dissimilar to the effects of the daytime activities proposed in this location, with certainly a high frequency of use if adopted for commercial recreation activities. As I set out in my evidence, I do not consider that there are any adverse cumulative effects that could be said to be more than minor. Cumulative effects raised by Ms. Tate appear to be more based with the total quantum of temporary events proposed, with all those being at the stables, farm building and outdoor area 1, an assumption that each event will have 150 guests in attendance and extend 3 days, covering set up and pack down, and adding up those additional effects arising from permitted temporary filming events occurring on the property. As I mentioned above, I consider that our assumption of how the proposal will operate in practice is quite extreme and unrealistic. I do not agree with Ms. Tate's suggestion that a significant bond be provided to ensure works are done to the heritage buildings. I believe the Buckham's evidence is conclusive and that they are good custodians of the buildings and property. The notion of a bond has no planning foundations in the circumstances surrounding this application, in my view. If there was a precedent arising from this application, as has been asserted by Ms. Tate, I would consider it to be positive in the way that the proposal assists with the sustainable use of the heritage buildings within a heritage setting. Even on this particular point, I can think of one other local example where this has occurred in recent times. In my opinion, a conclusion of a negative precedent would be very difficult to reach in the context of this proposal. The approach taken by Ms. Tate, following on from Ms. McConnell, is that commercial activities in the zone fall foul of many of the objectives and policies of Chapter 24, simply because they are commercial. This is not what the plan directs and is also not supported in my assessment of the permitted baseline. Mr. Hayes responded to Dr. Treverthen's comments and his evidence. I understand that all experts are in general agreement as to the extent of noise effects. I agree with Dr. Treverthen's suggestion of a condition to provide respite to the consistency of events, although I do not agree that the acoustic evidence supports the suggested 8-day respite period. While compared against the permitted baseline, I do not consider it necessary, but I've nonetheless included conditions 5 and 6 to further shape the proposal to help maintain the quality of the environment. So in summary, there's nothing in this evidence that leads me to alter my opinions that I've expressed in my evidence. And in conclusion, I maintain my opinion that the effects of the proposal will be appropriate alongside my updated suite of conditions, such that the required tests will be met by granting consent. The proposal overall is supported quite strongly by Section 6F of the RMA, which is protecting historic heritage as a matter of national importance and overall promotes the sustainable management of the land and building resource. Thank you.
Thank you very much. Do you have any questions?
Yeah, just before questions, could I just make, I just picked up an error in my evidence in chief, which I'd just like to correct if possible there. If I can just draw you to paragraph 3.27, which is on my page 6, about sale and supply of alcohol.
3.26?
3.27.
Sale of supply of alcohol.
Yeah, I state there provision will be made for alcohol to be consumed as part of the temporary events. I just want to make that clear that it's not part of all temporary events, just in case that could be inferred that way.
So what are you changing it to?
Provision will be made for alcohol to be consumed at some temporary events.
Okay.
Thank you. Any other changes? I should have asked you that beforehand. Any other changes you'd like to make?
No.
Thank you. Commissioner?
Maybe we'll start with marquees. Marquees don't seem to have been particularly well assessed. Obviously, we've now reduced the number of activities to 100 and the pack up, pack down days to 1. So 300 days of the year there could be a marquee up. Am I right?
Yeah, I think if you work on the basis that if all the 100 events are on the red barn and an outdoor area too, that could be the worst case scenario. I think it's probably quite extreme and unrealistic, but that could be an extreme worst case scenario, yes.
So if a marquee was up 300 days of the year, have you assessed that?
No, I haven't, not in that particular context, because in my assessment, I've really been considering the effects of the proposal spread across the property. If it was a concern and a fear in terms of an effect, the way to cap that would be to put a condition of consent, limiting it to a number per year. Yeah, I guess the locations of those marquees, in my view, aren't highly visible locations. I'm just trying
to find the locations of the marquees. Where is the good plan with that?
Yeah, so the two plans appended to my evidence. So you've got the first plan shows the heritage buildings, which is the barn and outdoor area too.
Yes.
From what I understand from the Buckhams, the marquees that have been put up in the past are either behind the barn or to the east of the barn.
Is there a plan which actually shows those areas? Because it's obviously referred to in conditions, isn't it?
Yeah, it refers to the whole of outdoor area too for that and all of the ruins.
So we're talking about this plan here, yeah?
Yes.
You can't see it? Right, so yeah, that's the trouble zone, sorry. So we're talking about your plan, 2nd September, yeah, with Scott, outdoor area 1, outdoor area 2
yes.
on it. And you're saying to the north of the barn is predominantly where they held, so
the north and the east of the barn.
East, okay. Because it makes logical sense, because to the north of the barn seems to be under some drip lines of some trees, but it depends on the size of the marquee, I suppose, doesn't it?
Yeah, correct. The other marquee area was in the ruins, and as you would have seen from when you're there, that's a relatively discrete area. I'd be relatively, I guess, reserved about putting an onerous condition on marquees there, because I just think from a visual perspective, it's not going to be highly visible. It's going to be relatively well tucked away from views from Speargrass Flat Road, certainly from private views.
I think at this time of year, the ruins were fairly easily visible from Speargrass Flats, and any marquee would probably be visible, particularly on white ones. So I would disagree with you from our site visit at this time of year.
So we interrupted your train of thought of where these marquees were going. So predominantly to the north and east of the barn. Where else were they going to Area 1 as well?
No, not in Area 1. That's excluded from that.
Right, I thought that was
so only the ruins.
Right, so we only have the potential for marquees to be in the area, outdoor area 2, and sort of to the north of the ruins.
Yes, correct.
Thank you. Sorry to interrupt you, Commissioner.
No, that's all right. So are you restricting it to the north of the ruins and to the north of the barn? Because the condition obviously is wider. The condition just says the ruins and outdoor area 2.
Yes. Can I just ponder that, please?
Yeah, there can be something to reply. And also I would like to think about restricting the days, because to me 300 days of the year is quite significant. Without actually passing judgment, I'm just putting it to you that it sounds quite a lot.
Yeah, if I can just ponder that, I'll respond with a little bit more detail. I think a condition could be quite suitable.
Gotcha.
You can ask some questions.
Okay. So just coming back, if I understood correctly, the construction of the fence along between 67 and the site, that's not a permitted activity, is it? And that wouldn't form part of any baseline, would it?
I've covered that off in my evidence, and in terms of it being requiring a consent, it requires consent on the assumption that it's within the heritage setting, and we're not 100% clear whether it is. We've made the assumption almost as a worst case scenario based on those plans in the district plan, because the underlying zone would actually be permitted. And the other thing, as I've been listening to some of the questions this afternoon, it's also permitted for the neighbour at 67 Speargrass Flat Road to erect a fence. So there's no, whether or not this fence gets constructed or approved for constructed, there's no certainty that there won't be some form of structure there at some point in the future, but that we don't have any control of.
So that's why I suppose that comes out to what we were discussing about where that big line is on the district plan, where it actually is. So that comes to the rationale for the actual applying for it as part of this consent. Yeah, that's correct.
It's a belts and braces approach.
That's fair enough. That's all good. And I suppose you would, so picking up the question my colleague was asking, Mr. Hay, about the noise, without that fence, what would, if we, in terms of the effect from a planning point of view, what would you say there would be on 67 if the fence wasn't there?
Yeah, it's really interesting, because I was pondering that with the Buckham's property as it stands now, they can undertake in that area 7 temporary events per calendar year with no mitigation, no noise controls. Obviously, they've got the Section 16 matter to abide by, but in terms of that was kind of where I kind of arrived at saying unfettered, and it's probably not entirely unfettered, but that is a use that could be undertaken there, well, up to 500 people. When, and I think it was actually one of the questions from Commissioner Baker earlier on, when she was questioning Mr. Hay on the 8 p.m. Time period. If I don't know if you've got chapter 35 available in front of you by any chance. If I can refer you to a rule. It's 35.4.5. So when the PDP was notified, the application site was actually part of the rural zone. And if you look at point C of that rule, which is on page 35-5, it states in the rural zone, the event does not operate outside the hours of 8 a.m. to 12 a.m. midnight. And all other zones, and then it brings in the restriction from the 8 to 8 a.m. to 8 p.m. It was actually an oversight in the plan and actually an error, because when, after the plan was notified, the council then notified a variation to the PDP, which was the Wakatipu Basin amenity zones and the rural lifestyle zone. But as part of that, they didn't address the respective noise rule for the temporary events within Chapter 35. And inadvertently, that's where this all other zones and the 8 p.m. restriction kicks in. So that actual, from when the Buckhams have been undertaking temporary events under the old ODP, they're actually entitled to undertake events up to 12 a.m., arguably because they have no existing use right certificate. They haven't had that tested. But that's been from my assessment that they've actually got the allowance up to 12 a.m. and not 8 p.m. And the noise limits will kick in at 10 p.m. still in accordance with that rule.
I lost you on that.
So that's okay. So I understand what you're saying. So that would apply for the 7 events. That would apply for those, wouldn't they?
Yes, correct.
So if we, because now we're going to 24, right, or it's been reduced down to 24 at 75. I'm just trying to get my head. I think we're both trying to get a head around. It seems to us that this fence is quite integral to mitigating those impacts at 167.
Yeah, and I think just to go back to your original question, sorry, the most recent consent that I've seen that has had high daytime noise in close proximity to residential dwellings, and actually closer than what this property is Cargo Brewery at Gantley's and Arthur's Point, and I can find you the reference for that. And don't quote me on the precise number, but I believe that the council resolved in that circumstance that noise effects around the high 50s to low 60s was deemed, or might have been low 60s, were deemed appropriate for daytime noise effects from events on that property. And those, I think the dwellings would have been right on the boundary. So quite. Sorry, Commissioner.
That for the brewery at Cargo?
Yes, that's right.
I think I was the commissioner on that.
Okay, we've just got up Chapter 35 now.
Mm.
So we'll just go to that 35.
What is it?
35.4.5.
35.5.
35.4.5.
And point C. So just to recap on that, the point I raised before is that when the PDP was notified, it was the site was within the rural zone, and at that time the temporary events could be undertaken, including in outdoor area 1 through to midnight. And it wasn't until the variation to the PDP came through that put this site within the Wakatipu Basin amenity zones that this inadvertently fell into an all other zone, which restricted the temporary events down to 8 p.m. My view's always been that that those activities were lawfully established under the old ODP, so that they do have that allowance for greater use. It doesn't answer your question in terms of are the noise effects of the neighbours going to be appropriate without the fence. I think that's probably more of a question for Mr. Hay in terms of where that lands.
This is not under appeal, is it?
No, it's operative.
Yeah, I think your argument on temporary activities having an existing use right certificate might be a bit tenuous at best.
Okay, so all right, so okay, thank you. But you
right, cumulative effects. I know that Ms. Walt is going to provide a case about cumulative effects, but I'm quite interested in how this actually works. So there's a lot of reference to the filming, which can be undertaken for 30 days of the year. So, and that will still be able to occur, is your intention, with this consent. So on top of this consent, we can have 30 days of filming on each of the sites. So we can have 60 days of filming, is that right?
A little bit different. It's the rules provides for 7 days of filming per site. And then the balance of that is the logistics of setting up and packing down from those types of events. So that was never precluded. And I'm not sure if you questioned Mr. Buckham on it. The quantum of events, filming that they have on property, it does occur, and it's a property that people have a lot of interest in that regard. but it's never been anything of any quantum that we've considered needed to be restricted, and that was something we discussed quite early on in the piece.
So there's only 7 days of filming permitted?
Correct, on each side.
So 14 days of filming?
Yes, correct.
Ah, okay, so I must have misread that. So that would be on top of the 100 days?
Yes.
Okay, and in your view, is that a cumulative effect?
It's a potential cumulative effect if it occurs, and if the 100 events per annum occur. I don't believe it's definitely not a significant cumulative effect, and I'd even query as to whether it's adverse on balance of the positive effects of filming.
So just while we're talking about that, you talk in your evidence about Ms. Buckham having a helicopter license. Where on the site would they land?
If they use the helicopter,
do they have one, and do they have a helipad? Do they land on the site?
No, I don't believe they do.
Oh, so there's no landing area that they. No, okay.
No,
So
it was hypothetical as part of my presentation.
Oh, sorry, I misunderstood. I thought she had one. So.
Oh no, he does have a helicopter, but he, from my understanding, he doesn't land it on the property.
He keeps it out of the airport. Okay. Oh, good. All right. Thank you. That solves that problem. Thank you. Go back to you.
Oh yes, I want to talk to you, Mr. Giddens, about the income generated and that being reinvested. And I accept that Mr. and Mrs. Buckham have done an excellent job at maintaining this property, but they are not necessarily the owners in perpetuity. How do we, or is it necessary for us to gain any certainty that money will be reinvested into the heritage maintenance? And if so, how do we achieve that?
Yeah, again, I've been pondering that through your earlier questions, and I don't believe it's necessary, because I think the evidence shows from the Buckham's own evidence and the photographs that they are those good custodians and have been doing this. It leads to your secondary question saying, well, if they sell the property for argument's sake, does it mean that someone else is going to be doing that? I think the evidence from the heritage, even from Mr. Miller, was quite clear that irrespective of these properties are always going to need these minor repairs and maintenance. It's just an ongoing battle. I've got heritage buildings myself, so I feel the pain and cost. But in terms of providing certainty within a consent framework, I did have a wee play around with how a condition could look along those lines, and I don't think it would be enforceable. And I don't think it would be firm enough to do, because the other problem that arises from the heritage buildings is, unless you have a plan of works, things that need to be done, as Mr. Miller was mentioning, 1 year you may not need any maintenance works at all, but the next year you might need quite considerable works, and it's going to vary as time goes on. I think trying to incorporate that into a consent framework would be quite difficult. The way I've been looking at it in terms of the positive elements of the Buckhams incorporating this into their proposal was the fact that the only people who are going to pay for the renovation of this building are the Buckhams, being the owners. So any money in their pocket is going to be inadvertently, one way or another, going to be used to maintain those buildings as they have done. So that's about the extent as I've drawn from it, Commissioner.
Yes, I mean, I could think of conditions. I was more interested in whether you thought it was necessary.
Yeah, another example I can refer you to is on Macdonnell Road. There was a consent signed off there a year or so ago for quite major renovations to heritage buildings, which were going to be turned into specific standalone event facilities, so quite different. But they proposed to do works as part of that consent, because the buildings were essentially dilapidated. Whereas it's quite different here, where the landowners actually maintained and kept them in relatively good order. So it's a little bit different. I don't know how we'd address that by a consent framework. Sorry, your speakers are on mute.
I don't know what's going on here. So,
Sorry.
I don't know what's going on. My apologies.
I was just making the assumption you were talking then. So.
No, our apologies. So just while we're waiting for my colleague to, my fellow commissioner to come through, do you know off the top of your head what the height of a permitted activity for a fence is? So we're on 67, which is not in the grade 1 listed area. Is it a 2 metre high closed boarded fence? Is that a permitted activity in the zone?
So on the property of 67, if they were to construct a fence,
we're outside the heritage stuff.
So 2 metre high? Yeah, 2 metres high, but there's no requirement for wooden paling. There could be a stone wall, could be a brick wall.
Yeah, but it could be a closed. I could choose to build a 2 metre high closed boarded fence if I wanted to, type thing.
Correct.
Thank you. I thought that was the case. Thank you.
The issue of reverse sensitivity. So you've addressed that at 7.48 of your evidence. And you've said it's unlikely that reverse sensitivity will arise to the detriment of the temporary event. And then you've said if there was noise from a lawnmower, for example, the size of 67 Speargrass Flat Road is that the effects would be short-lived. Now, I accept that they would be short-lived, but if that's in the middle of the wedding ceremony, that's going to be a reverse sensitive effect. Equally, if they decided to ride motorbikes, or a property across the road even decided to ride their motorbikes around, I can imagine that those noises which are accepted as part of residential activity or rural residential activity would be potentially subject to complaints by the consent holder of this consent because it's disrupting their event, which is clearly reverse sensitivity.
Yep, there could be a risk, and I guess if you look at the worst case scenario of a neighbour deciding to be malicious and during a ceremony as well, I think that's just the reality of where the site's located. There's only, in my view, only one neighbour I'd deem in close proximity across the road. They are in proximity, but I wouldn't call that close enough, certainly enough to create a reverse sensitivity disturbance. I think the risk would be more on outdoor area 1. And if there is an issue like that, it would have to be dealt with by the consent holder.
Well, I suppose we have to look at the effects now. So I'm looking at thinking of the reverse sensitivity effects.
Yeah, it's an interesting one because I think in terms of reverse sensitivity effects, if you're looking at what activity could disrupt a temporary event on the property, lawn mowing would probably be the most sensitive, I would have thought, and that's obviously looking at reverse sensitivity back on the property itself, of course.
I mean, there's potential for quite noisy activities to take place in rural living situations. So I think it is a realistic point that does need to be thought about.
Yeah, if we look at the quantum of activities proposed in AA1 down to 24 events, I think the risk that those 24 events are all going to be undertaken at a time where the neighbours decide to mow lawns, I think would be relatively unlikely. It may happen, but I wouldn't put it at high risk as a reverse sensitivity issue. Much different than building a house next to like a gun shooting range or something to that effect.
Sorry, I don't know
how we keep getting muted, but we were muted.
Sorry, I assume you're talking to yourself.
We seem to keep automatically getting muted for some reason. Paragraph 760, you have deferred to the experts in terms of accommodating traffic on site, which is in terms of safety and efficiency totally appropriate. But there's also a fairly significant visual effect of parking 50 cars on site. None of those locations seem to be particularly screened.
Yeah, I've always my view's always been that they're fleeting and temporary, and there's some commentary in my evidence. I can't think of the reference there where I talk about that also in light of marquees and that as well. The plan doesn't prevent cars from parking on site. So obviously there's a quantum difference here with potentially up to 50 vehicles. But on the basis of the temporary nature of them, I'm quite satisfied that it wouldn't be a significant effect, or it'd certainly be a minor effect. If they, for example, if the parking areas were defined areas, so they were there and used on a frequent basis, I think that would probably warrant a little bit more softening. But on the basis of that infrequency, I'm quite satisfied where I've landed.
100 days a year.
Up to.
You're applying for 100 days a year. You have to assume it's 100 days a year.
Yeah, I think if you look at the resource consent condition I put forward, in conjunction with Mr. Bartlett, I'll just give you the reference there. Condition 28, and the whole intent of that was to stagger parking as well, and that wasn't only just for management of parking, and the operational component was also for visibility and just avoiding disturbance in general. So I think when the Buckhams have been, I think, quite clear in the difficulties I've had with framing the proposal, and we've been working with them a long time to try and help them to do that because the property is so big and diverse. That condition was my attempt at trying to put some scale around the parking. So you've actually got a bit more certainty as to what range of vehicle parking may eventuate from the events, rather than saying there's got to be 150 events. Each of them are going to have 50 car parks, and they're going to be parking right here by the road.
But it could happen. The consent that has been, am I muted again? I'm muted. Oh, okay. But it could happen. I mean, the reality is that the consent as it's being sought is for 100 events, up to 150 people. So we have to assume that 100 days of the year there could be 50 vehicles parked on this site in visibility, visible from the road, and that's what we need to assess. Anything less than that, and we're just not assessing the proposal properly. So I understand what you're saying, and I understand what Mr. Buckham is saying, that may not be what they're thinking is actually going to happen, but in reality someone else could pick up this consent and could do that.
Yeah, I think there's probably two responses to that. One is that landscaping is incorporated, lower level landscaping around the key parking areas, because there are some very logical parking areas on the site, which I think would probably be more used than other sites. That's one. I think it's quite an easy.
It's incorporated. Have we got a landscape plan?
No. And that's not part of the proposal. I'm just talking about options. If it was. And then the second point was if the quantum of events was a problem, having to make an assumption that there's going to be 100 events per annum with 150 people there, 50 car parks. My view on a response to that, I'd have to discuss the logistics with the Buckhams, but it may well be that there be a staggered condition that allows, say, up to X amount of events between 100 and 150, X amount between 50 and 100, and X amount of events between 10 people and 50 to reduce that quantum. I think that's a tool that's available to the commissioners, and it could be something that after some discussion with the applicant we could discuss.
Okay, we'll look forward to that in the reply then at some point.
Sorry, you're getting my sunlight at the moment.
That's all right.
Oh yes, you're very hazy.
You're very.
Okay, we can see you. Okay, no, I don't have any further questions for you. Thank you, Mr. Gibbons.
No, actually, you've answered it. I just thought you were giving me the answer to the question. No, it's all good. Thank you.
Great.
Thank you very much. That's very, very helpful. Thank you. Is there anything else you want to ask with any other witnesses before we?
I have got answers to all my questions, I believe.
So have I. Ms. Vogt, is there anything more you'd like to bring to our attention before we in your case and move on to the submitters? Is there anything more you'd like to bring to our attention?
I could address you further on the line of questions you had for Mr. Miller regarding the cattle stop and gates on
very
7.
Yeah, are they related to each other? Because it looks to me that, I mean, I'm not a heritage expert, so I could be 100% wrong, but they look like they're the same period.
I believe they're not. So Buckham, and so firstly, cattle stops weren't a thing in the 1880s. They were an invention of the 20th century. And yes. I understand from the Buckhams that the schist cladding that is on those gates has only relatively recently been installed, and that was by the current owners. And prior to that, they were just concrete posts. Right, and so Mr. Miller has also sent through some photos, and I can put them to you if you'd like to see them. Aerial photos of old photos which show the tracking so on the property, so you can see where the videos off, not that that matters. So you can see how the property was accessed, and it wasn't through this site. The other point I'd draw your attention to is the Heritage New Zealand listing, which is appended to Mrs. Buckham's evidence.
Yes.
Page 7 of that listing contains a description of the Gordon era, which is when this house was built. And actually, I'll just grab that because I don't have it in front of me.
Got page 7, yes.
I believe it's toward the bottom of that page. I'll just find
the Allen era. The Gordon era, yeah, I see.
So perhaps if you just read that, yeah, and it paints quite a here we go. It paints quite a grim picture. So if I read it to you, in 1943, Gordon purchased Thirlby. The home said was in poor condition. Although sturdily built of stone, it lacked adequate foundations. The lintels were also too light for the heavy stone load. Vandalism and weathering, especially once the corrugated iron roof had been removed, meant the building was beyond repair. In the early 1950s, Gordon built a single-storey dwelling close to the eastern elevation of the stables. He vacated the homestead and it was left to decay. When a local stone tavern, that's Gantley's, was restored in the 1960s, Gordon gave Thirlby's roof and stone from walls to the restoration project. The building's neglect did not go unnoticed nationally. In 1952, Thirlby was used as an example of New Zealand neglecting its past. A design review article lamented that the steps of our predecessors are rapidly disappearing. This is becoming an urgent matter as every month some irreplaceable token of vanishing past is destroyed without trace or record. In 1977, Gordon demolished 2 of the remaining walls for safety's sake. Some of the material was used to build a smallest home nearby. So I guess the point there is in the Gordon era is not a it's more of a I suppose a darker part of Thirlby's heritage. As I've said, I can provide you with these photos that Mr. Miller has provided to me. I think they demonstrate that those the access to the property when it was used for farming purposes and from which its heritage values are derived was through the current entranceway next to the stables. And what you see in that photo in Mr. Brown's evidence is a much more recent addition, as the Buckhams have explained. That's only very recently been clad in schist. So I think I think that that's fairly conclusive that those gates were not part of the original layout of the property and are a later addition. And if you want me to, I can address you further on that in closing. And as I say, I can provide you with those photos from Mr. Miller, but that may be what I've just addressed now.
I'll just mute us for a moment, Rebecca, and I'll just talk to.
We're having problems. Sorry, we're having real problems with these muting buttons. We apologize. No, it's all right. It's all good. You've answered the question. You've brought it to our attention. I'm sure if there's something different, Ms. McDonald will bring it to our attention tomorrow as well. So thank you very much for that.
Thank you. Well, that's the only thing I wanted to address you on further at this point in time. Obviously, there's a bit that's come out of today in terms of consent conditions, and we'll work on those over the course of the hearing as intimated in my opening, but otherwise that's where things are for the case for Mrs. Buckham for the time being. Thank you, and
when we get to the end of tomorrow, I mean, I would imagine there'll be a new set of conditions, well, we imagine there'll be a new set of conditions coming in your right of reply anyway, so to address some of the things we've been discussing, I'd imagine. Sorry, I couldn't quite understand here. Was that in anticipation of further conditions being provided tomorrow or at a time subsequent? Yeah, I was just saying that as part of your right of reply, I imagine there'll be a newer updated set of conditions to reflect what we've been discussing today. Yes, certainly that's our intention. And just on the right of reply in terms of housekeeping, is is the expectation that would follow in writing, or would you like a reply to be given tomorrow? We would both just had that discussion in the break, and we can discuss later on tomorrow where we land, but usual practice is 5 working days. But if you need more time after what we hear tomorrow, that's perfectly acceptable for us. But our expectations it would be right in probably 5 working days, unless there's a need for any further time, if that's all right with you. Yes, thank you. Okay, thank you very much, Ms. Bob. Very appreciative of that. Thank you for your case. We understand that we have one submitter that needs to go today before we move over to Ms. McDonald representing all the other submitters, and that's Mr. Gleeson. Are you there?
Yes, Commissioner, that was good timing. I've just joined in now.
Oh, look at that. So we've got your submission here on behalf of James Robinson and the Buckham Key Limited.
Yeah.
We've just been given this today. We haven't read it, so would you like to read it out to us?
Yes.
And then at the end, take some questions. And if I don't know if you have been listening today, if there's anything else you'd like to bring to our attention from the course of the day, you're most welcome to do that as well.
Yes, happy to proceed on that basis, Commissioner. I'll read my there's a correction I wish to make, but I might just read through it, and then when I get to the paragraph.
Thank you.
So James Robinson and Whakataki Limited oppose the application by Victoria Buckham for commercial activity comprising 100 events per calendar year at 31 Speargrass Flat Road, Dalefield. The submitters have sought the application be declined unless changes are made to reduce the scale of the proposed activities, and the proposal in its current form must be declined consent, given it is a non-complying activity under the Queenstown Lakes proposed district plan and must accordingly meet the gateway test under section 104D of the RMA. The first gateway under section 104(1)A is not met, as the adverse effects of the activity on the environment cannot be shown to be minor or less than minor. And the second gateway is also not met, as the proposal will be contrary to the objectives and policies of the PDP. And the submitters agree with the recommendation of Ms. McConnell for the Council to decline consent. The issue of the nature of the activity there's disagreement between the planning experts as to the nature of the proposed activity and consequently the provisions of the PDP that are relevant. Mr. Giddens, for the applicant, considers the proposal is to undertake a number of temporary activities as defined in the PDP. He says it is therefore subject to the rules and standards set out in Chapter 35 as opposed to Chapter 24 or the district-wide rules and standards that would otherwise apply. This is on the basis of Rule 35.3.23, which provides that the rules of Chapter 35 take precedence over other provisions in the plan, with the exception of heritage and signage matters. The PDP definition of temporary activities, which I won't read in full, but as has been the subject of evidence, and I would assume the subject of today's discussion is this issue of the definition and the activities listed, along with the provision that they be of short duration, limited frequency, and outside the regular day-to-day use of a site. Mr. Giddens considers the definition of temporary activities is an umbrella term and that short duration, limited frequency, and outside the regular day-to-day use of a site, rather than being requirements in themselves, are used to describe the activities listed at A to G. He considers, provided an activity is one of those listed, it is deemed to and does not have to meet an additional requirement of being for short duration, limited frequency, and outside the day-to-day use of a site. Ms. Tate and Ms. McConnell, on the other hand, consider that part of the definition to be a requirement in order for the activities to be considered temporary. The submitters adopt Ms. McConnell and Ms. Tate's interpretation. If Mr. Giddens' interpretation was correct, it would mean the activities listed at A to G of the definition could be applied for under the temporary activity consent framework, even if there was no limit on the frequency at which they could occur. I would submit defeats the intention of the framework, which by definition is to relate to activities carried out on a temporary or infrequent basis. When interpreting plan provisions, it is relevant to consider the text of the provision, the purpose of the provision, the context and scheme of the plan, the history of the plan, the purpose and scheme of the act, and any other permissible guides to meaning. In this case, on a plain meaning of the provision, it is clear it contains a requirement that in order for the activities listed in the definition to be temporary, they must also be of short duration, limited frequency, and outside the day-to-day use of the site. And as Ms. Tate points out in her evidence, Mr. Giddens' interpretation was correct. Those words would be redundant. A purposive approach also supports this interpretation. As noted, it would be contrary to the intention of the temporary activities planning framework for activities regardless of their duration or frequency to be considered temporary. Similarly, based on the context of the plan, particularly the temporary definitions chapter, temporary activities chapter, it is justified to interpret the definition as setting a limit on what sort of activities would be considered temporary. It is acknowledged that definitions and plans should not require a value judgment or leave a discretion with the consenting authority as to whether an activity falls within it. Whilst the definition uses words that require interpretation, such as short and limited, these are commonly used words and descriptions often applied and assessed as part of interpreting legislative instruments and do not invalidate the definition. Words such as reasonable, for example, commonly appear in such instruments. The submitters do not consider the definition gives the council a discretion as to whether the activity falls within it. The terms are sufficiently objective to ensure the required certainty in regard to the application of the definition. Accordingly, the submitters consider the application is for commercial activities and is therefore subject to the relevant Chapter 24 and district-wide provisions. Section 104D of the RMA, and that first gateway under subsection 1A. In order for the proposal to pass the first gateway, the commissioners must be satisfied there will be no adverse effects on the environment that are more than minor. The onus is on the applicant to demonstrate such effects will be minor or less than minor. The submitters do not consider the commission can be satisfied that the effects will be minor or less than minor. The activities are of a commercial nature and are proposed to occur on a relatively regular basis. This is a significant change from the existing use of the site and the extent of activities that occur. It has not been demonstrated that this change will have a minor or less than minor adverse effect, in particular relating to the effects felt by neighbouring properties, the amenity of the existing rural living environment, and the cumulative effect of events occurring on a regular basis. As noted by Mr. Trevathan, acoustic expert for the submitters, that there is an information gap as to the effects of the proposal in terms of noise. Given such gap, the commissioners cannot be satisfied that adverse noise effects have been appropriately mitigated such that they will be minor or less than minor. Second gateway under 104.1b. The submitters say the proposal is contrary to a number of objectives and policies of the PDP. This is given the commercial nature and frequency of the activity and the inevitable change that will occur to the amenity of the surrounding environment. As Ms. Tate addresses in her evidence, the objectives and policies of Chapter 24 require non-residential activities to maintain or enhance amenity values, which creates a strict bar for such activities to meet. The scale of the commercial activity proposed will be out of character with its environment and will not maintain or enhance existing amenity values. The submitters adopt the assessment carried out by Ms. McConnell and Ms. Tate regarding the accordance of the proposal with the objectives and policies of the PDP and the conclusions they have reached. The proposal does not meet either of the gateway tests under section 104D of the Act. Accordingly, there is no discretion for the Commission to consider the proposal under section 104, and a decision to decline consent must be made. Alternatively, as set out in the submitter's submission, the application must be amended, and just a correction in terms of the numbers or number of events per year, that should not be 20 events per year. That the submission in fact sought that events that conclude after 8 p.m. and before 11 p.m. be limited to 20. And in fact, that has, as I understand, now been proposed, and I think it's the numbers at 12 events. So that's that last part of that paragraph is not to be taken as read. But that concludes my written commissions.
So there's no alternatively.
Correct.
So just take out all of 24 then?
Yeah, I think that's the easiest way to do it. Yeah.
Thank you.
And I do appreciate on that point that there have been some amendments made that have gone in the right direction in terms of addressing our clients' concerns. The issue, though, does remain being the total number of events that could occur and must be assumed will occur for the purposes of this assessment, and also the number of people.
Thank you. Do you have any questions?
Well, I suppose one of my questions was, is this based on the new proposal? But you kind of answered that, so it is.
Yes, it is.
Okay. Paragraph 19, you talk about the information gap. I gather you weren't listening earlier, so you may not know, but Mr. Hay, I think, has addressed this.
Okay.
But I might check that with Mr. Trevathan tomorrow.
Yes. Well, certainly we'd defer to Mr. Trevathan's opinion on that.
So your client's property is number 6 on the map of submitters that's attached to Ms. McConnell's 42A report. So they build on to the property, don't they? And so their access strip is between 67. So you go your client's access strip 67, and then the site, and then they have a long right of way that goes up to a house up above. Is that correct? Is that, if I got your
that's correct. Mr. Robinson's property is the triangular shaped land to the adjoining and to the east of the application site.
Oh, I get you. Right.
Yeah, no, I don't have that map in front of me, but
and so the bits on the lowland, is that someone else's property?
Which land is that? Sorry.
So I can't really see. It's a shame. Because on the map we've got, I don't know if you've got access to Ms. O'Connell's 42A report. On the map, we've got 6 in 2 locations, and there appears to be a boundary that runs along the sort of ridge, if you know that. So you've got the road goes flat and goes up. It seems the boundary goes along that ridge, and there's location.
Then, if you're referring to that thin area that then it forms part of the larger site, that sort of goes kind of to the adjacent on the eastern side, and then also part of the northern to the north of the site. That's the Whakataki property.
Right, I got you. Okay, thank you. No, that's all good for me. My colleague answered the appropriate questions. Thanks very much for your submissions. Thank you very much.
Thank you.
All right, and unless we have anyone else who'd like to go today before we go to Ms. McDonald tomorrow, who represents just working away through the list. I mean, it's 2, 19, 20, 21, 22, 23, 24, 25, 26, and 27. This is anyone else. I mean, I've got someone who says is unsure, but I think that's changed to support on the list I've got. So probably that's Stephen and Catherine Bates. So assume they're not here. If we don't have anyone else, Ms. McDonald, shall we come back to you at 9 o'clock tomorrow morning?
Yes, thank you, sir. That would be appreciated. My witnesses and myself have got ourselves all geared up to kick off then.
Sounds great. So what we'll do is, given we're all on Zoom, I'll give you a heads up. I'm going to return home and I'll be in my office in Auckland on Zoom, and my fellow commissioner will be in her office in Arrowtown on Zoom tomorrow. So we'll all be on Zoom in different spaces. And we'll pick up at 9 o'clock tomorrow morning, and we stand adjourned until then. Look forward to seeing you all then. Have a good evening, everyone.